Welcome to episode 37 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name's Bailey, and I'll be reading the Supreme Court's opinion in Chiles v. Salazar. The case was decided March 25th, 2026. And as always, we'll begin with the syllabus. Kaylee Chiles holds a master's degree in clinical mental health and a state counseling license in Colorado. Ms. Chiles does not begin counseling with any predetermined goals. Instead, she sits down with clients, discusses their goals, and then formulates methods of counseling that will most benefit them, seeking throughout to respect her client's fundamental right of self-determination. On matters of sexuality and gender, Ms. Chiles' clients, including young people, often have different goals. Some are content with their sexual orientation and gender identity and want help with social issues or family relationships, while others hope to reduce or eliminate unwanted sexual attractions, change sexual behaviors, or grow in the experience of harmony with their bodies. With all those clients, Ms. Chiles seeks to help them reach their stated objectives, and she employs only talk therapy. In 2019, Colorado adopted a law prohibiting licensed counselors from engaging in conversion therapy with minors, defining the term to include any practice or treatment that attempts to change an individual's sexual orientation or gender identity, as well as any effort to change behaviors or gender expressions or to eliminate or reduce sexual or romantic attractions towards individuals of the same sex. Yet the law explicitly allows counselors to provide acceptance, support, and understanding for identity exploration and development, and to assist persons undergoing gender transition. Ms. Chiles filed a suit in federal court seeking a preliminary injunction raising a First Amendment challenge to the law as it applies to her talk therapy. Both the District Court and the 10th Circuit determined that Ms. Chiles had Article III standing to pursue her as-applied pre-enforcement challenge. On the merits, however, both courts denied Ms. Chiles' request for a preliminary injunction, reasoning that Colorado's law is best understood as regulating professional conduct and that it regulates speech only incidentally, thus triggering no more than rational basis review under the First Amendment. This court granted certiorari to resolve a circuit conflict over how the First Amendment interacts with laws like Colorado's when those laws are applied to talk therapy. Held. Colorado's law banning conversion therapy, as applied to Ms. Chiles' talk therapy, regulates speech based on a viewpoint, and the lower courts erred by failing to apply sufficiently rigorous First Amendment scrutiny. Part A. The First Amendment protects the inalienable right of every individual to decide for himself how best to speak, and laws regulating speech based on its subject matter or communicative content are presumptively unconstitutional, triggering strict scrutiny that requires the government to prove its restriction is narrowly tailored to serve compelling state interests. Viewpoint discrimination represents an even more egregious form of content regulation from which governments must nearly always abstain. The court has recognized only a few historic and traditional categories of expression, such as fraud, defamation, and fighting words, where content-based restrictions do not automatically trigger strict scrutiny. These categories are narrowly drawn and share a long and well-recognized historical pedigree. A law regulating the content of speech cannot avoid searching First Amendment review just because it mostly regulates non-expressive conduct. What matters is whether, in fact, the law regulates speech in the case at hand, as illustrated by Cohen v. California and Holder v. Humanitarian Law Project. And the First Amendment's protections extend to licensed professionals as much as they do everyone else. Part B. As applied to Ms. Chiles, Colorado's law regulates the content of her speech and goes further to prescribe what views she may and may not express, discriminating on the basis of viewpoint. The law permits her to express acceptance and supports for clients exploring their identity or undergoing gender transition, but forbids her from saying anything that attempts to change a client's sexual orientation or gender identity, including efforts to change behaviors, gender expressions, or romantic attractions. Her speech does not become conduct just because a government says so, or because it may be described as a treatment or therapeutic modality. The First Amendment is no word game, and the exercise of constitutional rights cannot be circumscribed by mere labels. The fact that the state's viewpoint regulation falls only on licensed healthcare professionals does not change the equation. The First Amendment protects the right of all to speak their minds, and NIFLA expressly rejected the notion that professional speech is subject to diminished constitutional protection. History is littered with examples of governments that have sought to manipulate professional speech to increase state power, suppress minorities, and censor unpopular ideas. Colorado's law does not implicate any recognized exception to the court's usual First Amendment rules. It does not require disclosure of factual, non-controversial information in commercial speech, and as applied to Ms. Childs, it does not regulate conduct in a way that only incidentally burdens speech. All she does is speak, and speech is all Colorado seeks to regulate. Colorado's argument that the law regulates speech only incidentally fails because the court's speech incident to conduct doctrine asks whether the law restricts speech only because it is integrally related to unlawful conduct, or whether the law restricts expressive conduct only for reasons unrelated to its content. Colorado's law does neither. Ms. Childs' speech does not bear a close causal connection to any separately unlawful conduct, and the state's law trains directly on the content of her speech, permitting some viewpoints but not others. Part C. Colorado cannot establish that applying its law to Ms. Childs falls within a long tradition of permissible content regulation. Colorado's arguments proceed at far too high a level of generality, asking the court to recognize a broad First Amendment-free zone for speech the state considers substandard care. The court's precedents foreclose aggregating discrete traditions of content-based regulations to sustain some new and broader category of lesser protected speech. Even taking each of the traditions Colorado invokes on its own terms, none supports the state's position. Colorado's suggestion that the statute represents a traditional law licensing of medicine fails because the state has not presented persuasive evidence of a historical tradition. The first state counselor licensure bill was adopted only in 1976, and because licensing laws have traditionally addressed qualifications, not dictated a professional's point of view. Colorado's analogy to informed consent laws fails because such laws regulate speech only incident to separate physical conduct and usually require disclosure of only factual and uncontroversial information, whereas Colorado's law, as applied to Ms. Childs, seeks to silence a viewpoint she wishes to express. Finally, Colorado's invocation of traditional tort claims for malpractice fails because malpractice actions require exacting proof of injury caused by breach of duty, providing breathing room for protected speech. Whereas Colorado's law threatens fines, probation, and loss of license simply for expressing a particular view, and does not allow clients to consent to practices that depart from the prevailing standard of care. Part D. The First Amendment stands as a bulwark against any effort to prescribe an orthodoxy of views, reflecting a belief that each American enjoys an inalienable right to speak his mind and a faith in the free marketplace of ideas as the best means for finding truth. Laws like Colorado's, which suppress speech based on viewpoint, represent an egregious assault on both commitments. Justice Gorsuch delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Alito, Sotomayor, Kagan, Kavanaugh, and Barrett joined. Kaylee Childs is a mental health counselor in Colorado. In this case, we consider her First Amendment challenge to a state law regulating what she may say when speaking with her clients. Part 1, Section A. According to Ms. Childs' verified complaint, she holds a master's degree in clinical mental health and a state counseling license. Clients seek her help on a wide variety of mental health issues, including trauma, addiction, eating disorders, gender dysphoria, and sexuality. Ms. Childs does not begin counseling on any topic with any predetermined goals, nor does she seek to impose her values or beliefs on clients. Instead, she sits down and talks to them about their goals. Only after clients have identified their own aspirations does Ms. Childs begin formulating methods of counseling that will most benefit them. In any counseling that follows as well, Ms. Childs seeks to respect her client's fundamental right of self-determination. On matters of sexuality and gender, Ms. Childs' clients, including minors, come to her with different goals in mind. Some are content with their sexual orientation and gender identity and seek assistance only with social issues, family relationships, and the like. In cases like those, Ms. Childs does not try to persuade her clients to change their attractions, behavior, or identity, but aims instead to help them address their stated goals. Other clients, however, come to her hoping to reduce or eliminate unwanted sexual attractions, change sexual behaviors, or grow in the experience of harmony with their bodies. And in these cases, too, Ms. Chiles seeks to help her clients reach their own stated objectives. In doing so, she does not prescribe any medicines, perform any physical treatments, or engage in any coercive or aversive practices. All Ms. Chiles offers is talk therapy. Section B. In 2019, Colorado adopted a law prohibiting licensed counselors from engaging in conversion therapy with minors. The state reports that it adopted the law in response to a growing mental health crisis among Colorado teenagers and mounting evidence that conversion therapy is associated with increased depression, anxiety, suicidal thoughts, and suicide attempts. Any Coloradan who thinks a licensed counselor is engaging in conversion therapy may file a complaint with a regulatory board. A complaint, in turn, triggers a disciplinary review process that can yield a fine, probation, or the loss of a license. The term conversion therapy may evoke physical techniques, such as electric shock therapy aimed at changing an individual's sexual orientation or gender identity, but Colorado's ban on conversion therapy reaches further, forbidding any practice or treatment that attempts to change an individual's sexual orientation or gender identity. The law forbids as well any effort to change behaviors or gender expressions or to eliminate or reduce sexual or romantic attraction or feelings towards individuals of the same sex. At the same time, the law explicitly allows counselors to engage in practices that provide acceptance, support, and understanding for the facilitation of an individual's identity exploration and development. Likewise, the law allows counselors to provide assistance to a person undergoing gender transition. After Colorado adopted its new law, Ms. Chiles filed suit in federal court and sought a preliminary injunction prohibiting the state from enforcing it against her. She did not dispute that the statute has many valid applications. Indeed, Ms. Chiles did not take issue with Colorado's effort to ban what she herself calls long abandoned aversive physical interventions. Instead, Ms. Chiles objected to Colorado's law only as it applies to her talk therapy that involves no physical interventions or medications, only the spoken word. Ms. Chiles's as-applied challenge ran this way. With respect to gender identity, she claimed the law permits her to speak in ways that encourage a client undergoing gender transition, but the law prohibits her from speaking in ways that help a client realign his identity with his sex. With respect to sexual orientation, Ms. Chiles continued, Colorado's law similarly allows her to affirm a client's sexual orientation, but prohibits her from speaking in any way that helps a client change his sexual attractions or behaviors. Even though Colorado's law surely has other constitutional applications, she insisted, these constraints strip her of her First Amendment right to speak freely with her clients in ways she believes might help them meet their own goals. Section C. Both the District Court and the 10th Circuit determined that Ms. Chiles had Article 3 standing to pursue her as-applied pre-enforcement challenge. In support of their conclusion, both courts read Colorado's law as prohibiting licensed counselors like Ms. Chiles from engaging in any attempt, including through speech, to help a minor client change his gender identity or sexual orientation. Both courts understood this prohibition as extending to any attempt, including through speech, to change a client's behaviors or gender expressions, or to eliminate or reduce sexual or romantic attraction or feelings toward individuals of the same sex. As both courts saw it too, Ms. Chiles had previously spoken in ways the law now forbids, and she would continue speaking the same way but for Colorado's new law. Finally, both courts concluded that Ms. Chiles had alleged a credible threat that the state would enforce its law against her if she continued speaking as she had in the past and wished to do in the future. Indeed, both courts observed Colorado authorities had refused to disavow bringing enforcement actions against her. Under these circumstances, the courts held Ms. Chiles faced an ongoing injury resulting from the statute's chilling effect on her speech. Satisfied as well that Ms. Chiles's injury was traceable to Colorado's law and redressable by an as-applied constitutional ruling in her favor, both courts held that she possessed Article 3 standing to bring suit. In coming to this conclusion, the lower courts joined others that have found standing in similar cases involving similar statutes. Footnote 1. We too agree that Ms. Chiles has standing. Before us, Colorado only half-heartedly contests the point, suggesting Ms. Chiles cannot establish a present intention to speak in a way the law now forbids. But the state's argument is based not on some new insight about Ms. Chiles's state of mind, only a new and narrowed construction of the statute that the state advances for the first time in this court. Colorado's late-breaking construction of its law, however, would render much of the law's language superfluous. The state's new interpretation also seemingly stands at odds with how the state itself understood its law in proceedings below. Separately, Colorado suggests that Ms. Chiles has not shown a credible threat that the state will enforce its law against her, but Colorado has fought this suit through 3 courts over 3 years and, at argument here, expressly declined to disavow enforcement against Ms. Chiles. As the lower courts held, no more is required under this court's precedents. Carrying on. Turning to the merits, both the District Court and the 10th Circuit denied Ms. Chiles's request for a preliminary injunction. The courts recognized that Ms. Chiles provides only talk therapy, and they acknowledged that Colorado's law regulates the verbal language she may use. But the courts held the main thrust of the state's law is to delineate which treatments and therapeutic modalities are permissible. Accordingly, the courts reasoned that Colorado's law is best understood as regulating professional conduct. At most, they continued, Colorado's law regulates speech only incidentally to professional conduct. As a result, the courts concluded Colorado's law triggers no more than rational basis review under the First Amendment, requiring the state to show merely that its law is rationally related to a legitimate government interest. Because the state satisfied that standard, the courts held that Ms. Chiles was not entitled to the relief she sought. At the 10th Circuit, Judge Hartz dissented. As he saw it, the majority committed several fundamental errors. While Colorado's law may ban conduct in other applications, he observed, with respect to Ms. Chiles, it regulates only what she may and may not say, and under this court's precedents, he argued that kind of speech regulation triggers far more demanding scrutiny than mere rational basis review. Nor, Judge Hartz continued, does the fact that Ms. Chiles happens to hold a professional license change the equation. To the contrary, he said, the majority's effort to recast Ms. Chiles's speech as professional conduct amounted to little more than a labeling game. After the 10th Circuit ruled, Ms. Chiles sought certiorari. In doing so, she argued that the 10th Circuit's decision worsened a circuit conflict over how the First Amendment interacts with laws like Colorado's. We agreed to hear the case. Part 2. The question before us is a narrow one. Ms. Chiles does not question that Colorado's law banning conversion therapy has some constitutionally sound applications. She does not take issue with the state's effort to prohibit what she herself calls long-abandoned aversive physical interventions. Instead, Ms. Chiles stresses that she provides only talk therapy, employing no physical techniques or medications. Yet, she argues, Colorado's law still applies to her, prescribing what she may say in voluntary counseling conversations with her clients. And because that application of the law strikes at the heart of the First Amendment's protections for free speech, she contends, it warrants considerably more searching scrutiny than the rational basis review the 10th Circuit applied in this case or the intermediate scrutiny review some other lower courts have employed in cases like hers. We agree. To explain why, we begin by outlining the relevant First Amendment principles that govern us before discussing how they apply here. Section A. The First Amendment envisions the United States as a rich and complex place where we all enjoy the freedom to think as you will and to speak as you think. Often, speech may prove illuminating and inspiring. Sometimes it can be misguided, offensive, or cause incalculable grief. But either way, the First Amendment protects the inalienable right of every individual to decide for himself how best to speak. In this nation, no official, high or petty, may command our tongues or silence our voices. Consistent with the First Amendment's jealous protections for the individual's right to think and speak freely, this court has long held that laws regulating speech based on its subject matter or the communicative content are presumptively unconstitutional. As a general rule, such content-based restrictions trigger strict scrutiny, a demanding standard that requires the government to prove its restriction on speech is narrowly tailored to serve compelling state interests. Under that test, it is rare that a regulation will ever be permissible. We have recognized as well the even greater dangers associated with regulations that discriminate based on the speaker's point of view. When the government seeks not just to restrict speech based on its subject matter, but also seeks to dictate what particular opinion or perspective individuals may express on that subject, the violation of the First Amendment is all the more blatant. Viewpoint discrimination, as we have put it, represents an egregious form of content regulation, and governments in this country must nearly always abstain from it. Of course, with almost any rule come exceptions. And this court has recognized a few historic and traditional categories of expression long familiar to the bar, where content based restrictions on speech will not automatically trigger strict scrutiny, categories that include fraud, defamation, and fighting words. But as we have taken pains to emphasize, these exceptional categories are few and narrowly drawn, and all share a long and well recognized historical pedigree. Indeed, even within these categories, we have sometimes still applied strict scrutiny when governments have sought to regulate speech based on viewpoint. From these general principles, other more specific ones follow. So, for example, a law regulating the content of speech cannot avoid searching First Amendment review just because it mostly regulates non expressive conduct. Take a classic illustration, Cohen versus California. There, the state of California charged Paul Cohen with maliciously and willfully disturbing the peace. Often, of course, a person disturbs the peace through conduct alone, say by brawling at a city council meeting. But that is not always true, and in Mr. Cohen's case, California charged him for disturbing the peace because he wore a jacket bearing the words "fuck the draft" in a corridor of a municipal courthouse. As applied to him, the court recognized the law implicated core First Amendment concerns because the only conduct he engaged in was the speech he displayed, and we held California could not constitutionally punish him because of the content of his message. We repeated the point in Holder versus Humanitarian Law Project. That case involved a federal law banning the provision of material support to certain foreign terrorist organizations. Much as California had in Cohen, the federal government in Holder argued that the law did not trigger strict scrutiny because it addressed conduct, not speech. We disagreed. True, we acknowledged the law often might regulate conduct, but we observed, in the case before us, the government threatened to prosecute lawyers, doctors, and others for providing spoken training and expert advice, such as how to use humanitarian and international law to peacefully resolve disputes, to certain groups. And that application of the law, we held, sought to regulate speech on the basis of its content and thus demanded strict scrutiny review. As Holder indicates too, the First Amendment's protections extend to licensed professionals much as they do to everyone else. It's a point we have since discussed at length in NIFLA. There, California sought to require crisis pregnancy clinics to make certain statements to their clients. The state argued that its law did not trigger demanding First Amendment review because it sought to regulate only professional speech by state license holders. We rejected that move. By compelling clinics to speak the state's message, the law regulated speech based on its content. And we held California had failed to identify a persuasive reason for treating professional speech as a unique category, exempt from ordinary First Amendment principles. In reaching that conclusion, to be sure, we acknowledged two kinds of content based restrictions that can apply to professional speech without triggering strict scrutiny. First, courts generally deploy less searching review when faced with laws that require speakers to disclose only factual, non controversial information in commercial speech. Second, laws regulating conduct in ways that incidentally sweep in speech may also generally avoid strict scrutiny. As with laws addressing fraud, defamation, and fighting words, laws regulating speech along these two lines enjoy a long historical tradition. But we stressed neither turns on the fact that a licensed professional happens to be speaking, nor, we emphasized, do these narrow categories of lesser protected speech warrant a new rule exempting a broader category called professional speech from demanding First Amendment review. Section B. Applying these principles, we conclude that the courts below failed to apply sufficiently rigorous First Amendment scrutiny in this case. Start with the most obvious point. While the First Amendment protects many and varied forms of expression, the spoken word is perhaps the quintessential form of protected speech. That is exactly the kind of expression in which Miss Chiles seeks to engage. As a talk therapist, all Miss Chiles does is speak with clients. She does not prescribe medication, use medical devices, or employ any physical methods. Next, and nearly as clear to our eyes, Colorado seeks to regulate the content of Miss Chiles's speech. When it comes to issues of human sexuality, some of her clients are content with their sexual identity and orientation and want help only with social issues or family relationships. But other clients seek her counsel on how to reduce or eliminate unwanted sexual attractions, change sexual behaviors, or grow in the experience of harmony with their bodies. And in those cases, Colorado regulates how Miss Childs may respond. Under its law, she may not speak in any way that attempts to change a client's sexual orientation or gender identity, including a client's behaviors or gender expressions, or in any way that seeks to eliminate or reduce a client's sexual or romantic attraction or feelings toward individuals of the same sex. Doubtless, Colorado sees things differently. The state insists, and the 10th Circuit agreed, that its law does not regulate expression at all, only conduct, treatment, or a therapeutic modality. As a result, Colorado reasons, its law triggers no more than rational basis or intermediate scrutiny review. But the state's premise is simply mistaken. In many applications, the state's law banning conversion therapy may address conduct, such as aversive physical interventions. But here, Miss Childs seeks to engage only in speech, and as applied to her, the law regulates what she may say. Her speech does not become conduct just because the state may call it that, nor does her speech become conduct just because it can also be described as a treatment, a therapeutic modality, or anything else. The First Amendment is no word game, and the rights it protects cannot be renamed away or their protections nullified by mere labels. Our precedents have long made that much clear. California faulted Mr. Cohen for the conduct of wearing an offensive jacket. The federal government insisted that its law banning support to terrorists regulated conduct even as applied to the written and spoken advice of professionals like lawyers and doctors. But the effort to recast speech as conduct failed in those cases, and it must here too. Under the First Amendment, what matters is not how a government describes its law or whether the law may regulate conduct in other circumstances. What matters is whether, in fact, the law regulates speech in the case at hand. As applied here, Colorado's law does not just regulate the content of Miss Childs' speech, it goes a step further, prescribing what views she may and may not express. For a gay client, Miss Childs may express acceptance, support, and understanding for the facilitation of identity exploration. For a client undergoing gender transition, Miss Childs may likewise offer words of assistance. But if a gay or transgender client seeks her counsel in the hope of changing his sexual orientation or gender identity, Miss Childs cannot provide it. The law forbids her from saying anything that attempts to change a client's sexual orientation or gender identity, including anything that might represent an effort to change her client's behaviors or gender expressions or romantic attractions. Colorado disputes none of this, neither does the dissent. Of course, Miss Childs remains free to say other things. As Colorado and the dissent emphasize, she may share information about sexual orientation or gender identity. She can criticize Colorado's law. She can write papers espousing her views. She may even encourage a client to seek advice from someone else who doesn't hold a state license. But true as all that may be, it is also true that she cannot voice certain perspectives the state disfavors when speaking with consenting clients. And under our precedents, viewpoint restrictions like that are not subject to mere rational basis review or intermediate scrutiny. Rather, they represent an egregious form of content discrimination where First Amendment concerns are at their most blatant. The fact that the state's viewpoint regulation targets only licensed healthcare professionals like Ms. Childs changes nothing. Colorado and the dissent may believe that the First Amendment should carry far less salience for the nation's millions of medical professionals than for everyone else. They may believe that state-imposed orthodoxies in speech pose few dangers and many benefits in this field, and who knows what others. But their policy is not the First Amendment's. The Constitution does not protect the right of some to speak freely, it protects the right of all. It safeguards not only popular ideas, it secures, even and especially, the right to voice dissenting views. Consistent with these principles, our precedents have expressly rejected the state and dissent's notion that professional speech represents some separate category of speech subject to diminished constitutional protection. History is littered with examples of official efforts to manipulate and control professional speech, including the content of doctor-patient discourse, in ways designed to increase state power, suppress minorities, and muzzle unpopular ideas. And the dangers associated with censorship we have recognized are no less acute in the fields of medicine and public health than they are anywhere else. Nor does Colorado's law implicate any recognized exception to our usual First Amendment rules. As we have seen, some laws regulating speech based on its content, like ones addressing fraud, defamation, and fighting words, do not generally trigger heightened scrutiny because of their long historical pedigree. As we have seen too, NIFLA recognized that two kinds of such laws sometimes apply to professionals. But Colorado's law fits in neither category. The state does not require professionals to disclose factual, non-controversial information in their commercial speech. Instead, Colorado seeks to suppress views Ms. Chiles wishes to express. Nor, with respect to Ms. Chiles, does Colorado's law regulate conduct in a way that only incidentally burdens speech. All Ms. Chiles does is speak, and as far as she is concerned, speech is all Colorado seeks to regulate. Resisting this conclusion, Colorado and the dissent try to shoehorn the state's statute into the latter category. By defining prohibited conversion therapy broadly, Colorado observes, its law prescribes a wide range of treatments. Any activity that seeks to change a client's gender identity or sexual orientation, whether it involves electric shocks or consists of words only, is banned. And considering the full scope of the law's many applications the state submits, it seeks to regulate mostly conduct and reaches speech only incidentally. The dissent pursues a similar theme, insisting that Colorado has only incidentally prohibited Ms. Chiles' speech because the law's primary objective is to regulate medical treatments. This argument echoes Colorado's claim that it seeks to regulate only conduct, and they falter for similar reasons. If a government could reclassify talk therapy as speech incident to conduct, it might just as easily do the same for speech incident to teaching or protesting. Both are activities, after all. Were that the rule, what an opportunity for the suppression of dissent this would offer. Governments could easily wield all manner of laws regulating some conduct to silence speech they disfavor. It is a result that would not comport with the First Amendment's animating principles so much as betray them. Recognizing as much, our precedents in Cohen and Holder already foreclose exactly this move. California prosecuted Mr. Cohen under a law banning disturbances of the peace. The federal government threatened lawyers and doctors with prosecution under a law prohibiting support for terrorists. In both cases, the government defended its actions on the ground that the law in question was generally aimed at certain types of conduct, but in both cases, we emphatically rejected that argument. Just because a law may generally function as a regulation of conduct, we held, does not exempt it from demanding First Amendment review when a government seeks to apply that law to speech alone. At bottom, Colorado and the dissent fundamentally misconceive this court's speech incident to conduct precedents. In these cases, the question is not whether a law mostly addresses conduct and only sometimes sweeps in speech. Instead, the focus lies on two entirely different questions. Whether the law in question restricts speech only because it is integrally related to unlawful conduct, or whether the law restricts expressive conduct only for reasons unrelated to its content. Illustrative of the first category, this court has held that strict scrutiny does not apply to regulations aimed at speech promoting the sale of contraband, because such speech is often bound up with traditional criminal conduct. Illustrative of the second category, an ordinance against outdoor fires would not require a court to apply strict scrutiny even if it prohibited burning a flag in protest because the law forbids conduct without regard to the message it may convey. Colorado's law does not regulate speech incident to conduct under either test. The state does not dictate what Miss Chiles may say because her speech bears a close causal connection to some separately unlawful conduct like a traditional crime. Rather, Miss Chiles seeks to speak with interested clients about steps they might take to change unwanted behaviors, expressions, or attractions related to sexual orientation or gender identity. Conduct Colorado itself does not dispute those clients or anyone else may lawfully undertake. Nor does Colorado seek to regulate Miss Chiles's speech for reasons unrelated to its content, like a ban on outdoor fires that happens to sweep in flag burning. Instead, the state's law trains directly on the content of her speech and permits her to express some viewpoints but not others. Colorado does not regulate speech incident to conduct, it regulates speech as speech. Section C. Perhaps sensing that this court's existing precedents offer it little support, Colorado ultimately pivots, urging us to reshape our doctrine. In doing so, the state begins by pointing again to NIFLA. There, recall, the court observed that our cases have identified two circumstances in which speech by professionals may warrant diminished First Amendment protection: when a law seeks to compel disclosure of factual, non-controversial information in commercial speech, and when a law regulates speech only incidentally to conduct. Still, Colorado emphasizes, NIFLA left open the possibility that a future party might present persuasive evidence of a long, if heretofore unrecognized, tradition of content regulation regarding additional categories of professional or other speech that might likewise warrant only diminished First Amendment protection. Seeking to take up this challenge, Colorado contends that its law falls within a long tradition of permissible content regulation. It's a line of argument that comes with a daunting burden. Under our precedents, the state must present persuasive historical evidence in order to overcome our especial reluctance to mark off new categories of speech for diminished constitutional protection. Still, Colorado insists it can carry that burden in this case because states have traditionally enjoyed wide latitude to prescribe substandard care, even when that involves regulating the content of speech. As evidence, Colorado points to the history of state laws licensing the practice of medicine, regulating informed consent, and permitting tort suits for medical malpractice. The dissent pursues the same point, citing the same authorities. This argument stumbles out of the gate, for it proceeds at far too high a level of generality. From three specific sets of laws, Colorado and the dissent ask us to recognize a cavernous First Amendment free zone, one in which states may censor almost any speech they consider substandard care. It is, once more, an approach our precedents already foreclose. Consider a couple examples. In Alvarez, the federal government pointed to specific historical laws proscribing fraud and defamation and asked us to extrapolate from them a much broader rule allowing it to enforce content-based restrictions on any false statements. In NIFLA, California suggested that informed consent laws and our speech incident to conduct doctrine might be cobbled together to sustain the recognition of a field of professional speech subject only to rational basis review. We rejected both efforts, stressing instead that discrete traditions of content-based regulations cannot be aggregated together to sustain some new and broader category of lesser protected speech. And Colorado's similar effort can succeed no more than others like it have in the past. Beyond that problem lies another. Taking each of the three traditions Colorado and the dissent invoke on its own terms, as we must, none delivers the support they suppose. Start with Colorado's suggestion, endorsed by the dissent, that the state's statute represents nothing more than a traditional law licensing the practice of medicine. We cannot agree for at least two reasons. First, the state has not presented persuasive evidence that its law is part of a historical tradition. When assessed at the level of generality our precedents demand, what Colorado describes turns out to be a relatively recent innovation. Indeed, the briefing before us suggests that the very first state counselor licensure bill was adopted only in 1976. And that is far from the sort of persuasive evidence of a historically grounded practice our precedents require. Second, licensing laws have traditionally addressed what qualifications an individual must possess before practicing a particular profession. And whatever traditional interest a state may have in ensuring a professional possesses a particular set of qualifications, that interest does not automatically entail a right to dictate a professional's point of view. Turn now to Colorado's effort, again echoed by the dissent, to compare its statute to informed consent laws. Those laws generally require a doctor to inform a patient about the nature of a proposed procedure and its attendant risks. As such, informed consent laws do not usually trigger strict scrutiny because they regulate speech only incident to separate physical conduct that would, without the patient's consent, amount to an assault. Usually, too, informed consent laws require practitioners to disclose only factual and uncontroversial information. But all that is a far cry from how Colorado's law operates here. As applied to Miss Chiles, the state seeks neither to regulate her speech incident to any conduct, nor does it seek to compel disclosure of factual and uncontroversial information. Instead, it seeks to silence a viewpoint she wishes to express. Colorado and the dissent close by asking us to analogize the state's law to traditional tort malpractice claims. But here again, the differences are impossible to ignore. In a traditional malpractice action, liability attaches only if the plaintiff shows, among other things, that he has suffered an injury caused by the defendant's breach of the applicable duty of care. Those kinds of exacting proof requirements, we have observed, may provide sufficient breathing room for protected speech. Yet Colorado's law contains nothing like them, instead threatening individuals with fines, probation, and the loss of their licenses simply for expressing a particular view. Nor does Colorado's law allow clients to consent to practices that depart from the prevailing standard of care, while malpractice law sometimes does. Consider, too, where the state and dissent's logic leads. Not long ago, many medical experts and organizations, including the American Psychiatric Association, considered homosexuality a mental disorder. On the view Colorado and the dissent advance, a law adopted during that era prohibiting counselors from engaging in the substandard care of affirming their clients' homosexuality would have been subject to only rational basis or intermediate scrutiny review and likely upheld. Today, tomorrow, and forever too, any professional speech that deviates from current beliefs about the safety and efficacy of various medical treatments could be silenced with relative ease. It is a consequence Colorado freely acknowledges, and one the dissent embraces. So what if that kind of reflexive deference to currently prevailing professional views may not always end well? Compare Buck versus Bell. Fortunately, that is not the world the First Amendment envisions for us. Licensed professionals have a host of good faith disagreements about the prudence and ethics of various practices in their fields. Medical consensus, too, is not static. It evolves and always has. A prevailing standard of care may reflect what most practitioners believe today, but it cannot mark the outer boundary of what they may say tomorrow. Far from a test of professional consensus, the First Amendment rests instead on a simple truth. The people lose whenever the government transforms prevailing opinion into enforced conformity. Part 3. We do not doubt that the question how best to help minors struggling with issues of gender identity or sexual orientation is presently a subject of fierce public debate. But Colorado's law addressing conversion therapy does not just ban physical interventions. In cases like this, it censors speech based on viewpoint. Colorado may regard its policy as essential to public health and safety. Certainly, censorious governments throughout history have believed the same. But the First Amendment stands as a shield against any effort to enforce orthodoxy in thought or speech in this country. It reflects instead a judgment that every American possesses an inalienable right to think and speak freely, and a faith in the free marketplace of ideas as the best means for discovering truth. However well-intentioned, any law that suppresses speech based on viewpoint represents an egregious assault on both those commitments. The judgment of the 10th Circuit is reversed and the case remanded for further proceedings consistent with this opinion. It is so ordered. Justice Kagan, with whom Justice Sotomayor joins, concurring. The court today decides that the Colorado law challenged here, as applied to talk therapy, conflicts with core First Amendment principles because it regulates speech based on viewpoint. I agree. I write only to note that if Colorado had instead enacted a content based but viewpoint neutral law, it would raise a different and more difficult question. As the court states, governments must nearly always abstain from adopting viewpoint based restrictions. Those laws represent a particularly egregious form of content based regulation implicating First Amendment concerns to the highest possible degree. A law drawing a line based on the ideology of the speaker, disadvantaging one view and advantaging another, skews the marketplace of ideas our society depends on to discover truth. And such a law suggests an impermissible motive that the government is regulating speech because of its own hostility toward the targeted messages. If the First Amendment prohibits anything, it is the official suppression of ideas. Because viewpoint based laws always raise that specter, they are the most suspect of all speech regulations. So much so that this court has refused to permit viewpoint discrimination even within unprotected categories of speech like fighting words or obscenity. Colorado's law, as applied to talk therapy, regulates based on viewpoint for the reasons the court gives. The law forbids a counselor to provide therapy designed to change a minor's sexual orientation or gender identity. At the same time, the law specifically allows a counselor to offer therapy expressing acceptance, support, and other affirmation of the minor's identity exploration. So, for example, the law prevents a therapist from saying she can help a minor change his same sex orientation, but permits her to say that such a goal is impossible and so she will help him accept his gay identity. Colorado does not dispute that point, nor does it dispute that under normal First Amendment principles, that difference constitutes viewpoint discrimination. Indeed, the case is textbook. The law distinguishes between two opposed set of ideas, the one resisting, the other reflecting the state's own view of how to speak with minors about sexual orientation and gender identity. Or, said just a bit differently, the law draws a line based on the speaker's opinion or perspective and thus enables speech on only one side, the state's preferred side, of an ideologically charged issue. Of course, it does not matter what the state's preferred side is. Consider a hypothetical law that is the mirror image of Colorado's. Instead of barring talk therapy designed to change a minor's sexual orientation or gender identity, this law bars therapy affirming those things. As Ms. Chiles readily acknowledges, the First Amendment would apply in the identical way. Once again, because the state has suppressed one side of a debate while aiding the other, the constitutional issue is straightforward. It would, however, be less so if the law under review was content-based but viewpoint neutral. Such content-based laws, as the court explains, trigger strict scrutiny as a general rule, but our precedents respecting those laws recognize complexity and nuance. We apply our most demanding standard when there is any realistic possibility that official suppression of ideas is afoot, when, that is, a merely content-based law may reasonably be thought to pose the dangers that viewpoint-based laws always do. But when that is not the case, when a law, though based on content, raises no real concern that the government is censoring disfavored ideas, then we have not infrequently relaxed our guard. Just 2 terms ago, for example, the court declined to apply strict scrutiny to a content-based but viewpoint-neutral trademark restriction. In the trademark context, as in some others, experience and reason alike showed no significant danger of idea or viewpoint bias. The same may well be true of content-based but viewpoint-neutral laws regulating speech in doctors' and counselors' offices. Footnote 1. Justice Jackson's dissenting opinion claims that this is a small or even non-existent category. But even her own opinion, when listing laws supposedly put at risk today, offers quite a few examples. Her view to the contrary rests on reimagining and in that way collapsing the well-established distinction between viewpoint-based and other content-based speech restrictions. Carrying on. Medical care typically involves speech, so the regulation of medical care, which is of course pervasive, may involve speech restrictions, and those restrictions will generally refer to the speech's content. But laws of that kind may not pose the risk of censorship, of official suppression of ideas, that appropriately triggers our most rigorous review. And that means the difference between viewpoint-based and viewpoint-neutral content discrimination in the healthcare context could prove decisive. Fuller consideration of that question, though, can wait for another day. We need not here decide how to assess viewpoint neutral laws regulating health providers' expression, because as the court holds, Colorado's is not one. Justice Jackson dissenting. There is no right to practice medicine which is not subordinate to the police power of the states. This was true 100 years ago, and it should be true today. Many states have now chosen to exercise their police powers to ban conversion therapy based on the medical profession's broad consensus that this medical treatment, which seeks to change a gay or transgender person's sexual orientation or gender identity, is ineffective and harmful. This case involves the Colorado legislature's policy decision to prohibit licensed medical professionals from offering or providing conversion therapy to minors in that state. Petitioner Kaylee Chiles is a licensed counselor who works in the state of Colorado. She does not dispute that conversion therapy can be harmful to minors in certain circumstances, nor does she contest that Colorado has a significant interest in protecting minors from harm. Chiles complains, nevertheless, that because the particular form of conversion therapy she wants to offer clients utilizes only speech, the First Amendment prevents Colorado from prohibiting that treatment. But the power of government to regulate the professions is not lost whenever the practice of a profession entails speech. And medical professionals do not, generally speaking, have a right to use the Constitution as a weapon, allowing them rigorously to control the content of reasonable conditions that a state imposes on licensed healthcare providers for the protection of its residents. So I respectfully dissent. Stated simply, the majority has failed to appreciate the crucial context in which Chiles's constitutional claims have arisen. Chiles is not speaking in the ether. She is providing therapy to minors as a licensed healthcare professional. The 10th Circuit was correct to observe that there is a long-established history of states regulating the healthcare professions, and until today, the First Amendment has not blocked their way, for good reason. Under our precedents, bedrock First Amendment principles have far less salience when the speakers are medical professionals and their treatment-related speech is being restricted incidentally to the state's regulation of the provision of medical care. No one directly disputes that Colorado has the power to regulate the medical treatments that state-licensed professionals provide to patients, nor is it asserted that, when doing so, a state always runs afoul of the Constitution. So, in my view, it cannot also be the case that Colorado's decision to restrict a dangerous therapy modality that incidentally involves provider speech is presumptively unconstitutional. In concluding otherwise, the court's opinion misreads our precedents, is unprincipled and unworkable, and will eventually prove untenable for those who rely on the long-recognized responsibility of states to regulate the medical profession for the protection of public health. Part 1. To properly evaluate the First Amendment claim at issue in this case, one must first understand the impetus for Colorado's regulation, what the law requires, and the nature of the speech it implicates. Section A. Conversion therapy is designed to convert a person's sexual orientation or gender identity so that the person will become heterosexual or cisgender. Generally speaking, conversion therapy began as an attempt to cure gay and transgender people of their non-conforming orientations or identities. Conversion therapy efforts have historically included aversive therapeutic modalities. Those ranged from inducing nausea, vomiting, or paralysis in patients, or subjecting them to severe electric shocks, to telling patients to snap an elastic band on their wrists in response to non-conforming thoughts. Aversive therapies have now fallen out of fashion. Non-aversive treatments, primarily talk therapy, are currently the predominant form of conversion therapy. All such therapies seek to encourage patients to change their behavior in an attempt to change their identity. Over the past few decades, however, the premise of conversion therapy, in whatever form, has been widely discredited within the medical and scientific community. Conversion therapy is, at bottom, based on a view of gender diversity that runs counter to scientific consensus. That is, contrary to the core beliefs that undergird conversion therapy, a robust professional consensus now acknowledges that sexual orientations and gender identities range widely, and it no longer regards non-heterosexual orientations or non-cisgender identities as non-conforming. Because people's identities are simply a part of the normal spectrum of human diversity, the medical community has determined that efforts to change a patient's sexual orientation or gender identity will necessarily be ineffective. The American Psychological Association, for example, has found no empirical evidence that providing any type of therapy in childhood can alter adult same sex sexual orientation. And no research has been published in the peer reviewed literature that demonstrates the efficacy of conversion therapy efforts with gender minority youth, nor any benefits of such interventions to children and their families. Not only is conversion therapy ineffective, former participants of conversion therapy report that it causes lasting psychological harm. Gay and transgender children who underwent non aversive conversion therapy say they were taught to feel shame and self hatred. And survivors of conversion therapy continue to suffer from PTSD, anxiety, and suicidal ideation. As one survivor put it, conversion therapy came close to killing me. Footnote 1. Consider a specific example. An amicus who received conversion therapy as a child, Matthew Shirka, was told that his sexual orientation was a disorder either rooted in childhood trauma or stemming from an overbearing mother or absent father. In the course of this therapy, Matthew's therapist said that being gay was a mental illness that could be cured and that, unless he was cured, he could never live a happy and fulfilled life. Matthew's conversion therapists eventually hypothesized that his mother was the source of his sexual orientation and instructed him to avoid speaking with her. For 3 years, he had barely any contact with his mother. The years of conversion therapy brought Matthew nothing but increased isolation from his family, worsening depression, and suicidal ideation. Thus, as Matthew's experience illustrates, the harm from conversion therapy extends to the patient's family. Carrying on. The scientific literature confirms what anecdotal experiences suggest. Conversion therapy has harmed patients, particularly minors. The APA found that the reported negative social and emotional consequences of conversion therapy include self-reports of anger, anxiety, confusion, depression, grief, guilt, hopelessness, deteriorated relationships with family, loss of social support, loss of faith, poor self-image, social isolation, intimacy difficulties, intrusive imagery, suicidal ideation, self-hatred, and sexual dysfunction. Even for those study participants who reported positive effects initially, many described experiencing the negative effects later. Moreover, studies show that children often feel the effects of the shame and stigma from conversion therapy even more vividly than adults due to their increased emotional vulnerability and less developed capacity to cope effectively with the harm of discrimination. Ultimately, scientific evidence supports the conclusion that the anticipated harms from conversion therapy are twofold. First, conversion therapy stigmatizes the patient, telling them that their gender identity or sexual orientation is something to be fixed rather than accepted. This rejection can lead to shame and guilt, which in turn can cause long-term emotional distress. Second, conversion therapy sets patients up to fail by giving them an unattainable goal. Some patients have described that experience of failure as a significant cause of emotional and spiritual distress and negative self-image. Section B. In 2019, Colorado joined 25 other states in banning the practice of conversion therapy for minors. Colorado's law, titled the Minor Conversion Therapy Law, MCTL, prohibits licensed healthcare professionals from practicing conversion therapy with children. It defines conversion therapy as any practice or treatment that attempts or purports to change an individual's sexual orientation or gender identity, including efforts to change behavior or gender expressions, or to eliminate or reduce sexual or romantic attraction or feelings towards individuals of the same sex. Footnote 2. The MCTL primarily applies to licensed healthcare professionals. Such professionals are already subject to a number of other restrictions on their professional practice. Most relevant here, under Colorado law, licensed therapists must provide therapy that is consistent with the standard of care, defined as the standards of practice generally recognized by state and national associations of practitioners in the field of the person's professional discipline. Carrying on. Not all therapeutic discussions of sexuality and gender identity are prohibited by the MCTL. The law allows, quote, practices or treatments that provide 1. Acceptance, support, and understanding for the facilitation of an individual's coping, social support, and identity exploration and development, including sexual orientation neutral interventions to prevent or address unlawful conduct or unsafe sexual practices, as long as the counseling does not seek to change sexual orientation or gender identity, or 2. Assistance to a person undergoing gender transition. End quote. The Colorado legislature made these allowances after crediting witness testimony and professional consensus about conversion therapy, namely that it is harmful and that the preferred treatment for minors relating to their sexual orientation and gender identity is affirming care, i.e., medical care that helps minors focus on acceptance, support, coping, and identity exploration and development. Section C. Chiles insists that, although she is a counselor licensed by Colorado, she has a constitutional right to flout Colorado's statute and the standard of care it incorporates if a client asks her to do so. Never mind that medical professionals, including counselors like Chiles, are generally bound to follow medical standards and state licensing requirements when they provide medical care to patients. Chiles wants to offer patients conversion therapy despite the MCTL and the medical consensus it reflects. So she has invoked the First Amendment, arguing that because talk therapy is speech, no state can impose treatment standards like the MCTL on licensed talk therapists without first satisfying heightened scrutiny. As applied to Chiles, the MCTL treats the talk therapy form of conversion therapy as a prohibited medical treatment, but Chiles is free to express her opinion about the efficacy of conversion therapy or her disagreement with Colorado's conclusion that such therapy is harmful to minors. Colorado's law does not target or prohibit the expression of such views by anyone in any form, including by licensed healthcare providers in discussions with patients and their families. All that Colorado's law prescribes is the provision of such therapy to minors. This means that while Chiles can freely promote conversion therapy and vociferously decry the state's prohibition, she cannot practice that therapy without being subject to professional discipline under Colorado law. Part 2. I begin my analysis with a simple observation. Our First Amendment jurisprudence does not treat speech as existing in a vacuum. Instead, how the First Amendment applies to a state's power to regulate speech depends on the context in which the regulation of speech occurs. We have not mechanically held that the First Amendment protects all communicative content. Rather, we have evaluated First Amendment claims in a nuanced way, sensitive to both core principles and the specific circumstances under which the claim arises. In my view, then, it matters for First Amendment purposes that the MCTL restricts treatment-related speech uttered by medical professionals only as part of a larger regulatory scheme aimed at ensuring that providers tender high-quality medical care to patients. In Part 2A, I explain that this way of conceptualizing the question before us is not novel. We have long understood that states have the power to regulate medical professionals, and our precedents demonstrate that when a healthcare provider's speech is incidentally restricted as part of a state law scheme regulating the provision of medical treatments, the heightened scrutiny we reflexively apply in other situations is not warranted. In Part 2B, I show that First Amendment principles are not offended when lesser scrutiny is applied to a state law regulating medical treatments in a manner that incidentally restricts a provider's professional medical speech. Section A, subsection 1. A case that we decided in 2018, NIFLA, shows us the way to determine the appropriate level of constitutional scrutiny here. In that case, we began by explaining that speech is not unprotected merely because it is uttered by professionals. But, critically, we also acknowledged that the court has afforded less protection for professional speech in two circumstances, one of which occurs when a state regulates professional conduct even though that conduct incidentally involves speech. This acknowledgement was grounded in an already well-established principle. The First Amendment does not prevent restrictions directed at conduct from imposing incidental burdens on speech. To further explain the contours of this presumptively permissible speech restriction, NIFLA cited Planned Parenthood of Southeastern Pennsylvania versus Casey. In Casey, the court assessed an asserted First Amendment right of a physician not to provide information about the risks of abortion and childbirth in a manner mandated by the state. More specifically, Casey involved a challenge to a Pennsylvania law requiring that a doctor give a woman certain information as part of obtaining her consent to an abortion. Footnote 3. The First Amendment challenge to Pennsylvania's law in Casey was effectively the flip side of the one Chiles brings here. While the doctors in Casey complained that Pennsylvania was forcing them to speak when they did not want to, Chiles asserts that Colorado is preventing her from saying what she wants to say. Carrying on. We held that Pennsylvania's informed consent mandate did not violate the First Amendment. To be sure, the physician's First Amendment rights to speak were implicated by Pennsylvania's law, but we emphasized that those rights were implicated only as part of the practice of medicine subject to reasonable licensing and regulation by the state. Thus, there was no constitutional infirmity in the requirement that the physician provide the information mandated by the state. In NIFLA, we reaffirmed the principle from Casey that the First Amendment inquiry requires consideration of whether the regulated speech was made during the provision of medical care. NIFLA involved a challenge to a California law that required certain crisis pregnancy centers to post notices in their waiting rooms informing low-income patients that California paid for qualifying abortions. We asked whether, on the one hand, this law was regulating the clinic's speech qua speech, or whether, on the other, the notice requirement was actually regulating the clinic's professional conduct and only incidentally restricting speech. If the latter, the NIFLA court explained, California's notice requirement would fit into the category of cases that Casey illustrated, namely, those in which this court has upheld regulations of professional conduct that incidentally burden speech. Relying in part on Casey's analytical framework, the NIFLA court held that California's law regulated speech as speech. We explained this conclusion by contrasting the Pennsylvania regulation at issue in Casey. While the notice requirement in Casey restricted doctors' speech, it did so only as part of the practice of medicine. The notice requirement at issue in NIFLA, by contrast, was not an informed consent requirement or any other regulation of professional conduct. In fact, California's notice was not tied to a procedure at all. It applied to interactions between a covered facility and its clients, regardless of whether a medical procedure was ever sought, offered, or performed. So, we reasoned, unlike Pennsylvania's informed consent requirement in Casey, California's notice mandate warranted heightened scrutiny because it regulated speech as speech. The takeaway from NIFLA is that Casey applied a lower level of scrutiny because the law in Casey restricted speech uttered in the course of and as part of providing professional medical care. By contrast, the notice requirement in NIFLA was not tied to a procedure at all, and therefore meaningfully different. That law restricted speech as speech. Thus, the key distinction, as the NIFLA court saw it, was whether the challenged law was a regulation of speech as such, or a regulation of professional conduct that incidentally burdens speech. Subsection 2. Given all this, one might think today's majority would make more of an effort to explain why the MCTL does not likewise qualify as a regulation of professional conduct that incidentally burdens speech. Such an inquiry would entail evaluating whether the MCTL's restriction on Chiles's therapy only incidentally restricts Chiles's speech by virtue of the fact that the medical care she provides is delivered orally. It would also require acknowledging that the MCTL's restriction on Chiles is plainly tied to the provision of a medical procedure, one that, but for Colorado's law, a licensed counselor like Chiles might offer to minors. In my view, it is obvious that the MCTL is regulating professional conduct insofar as it prohibits providing a particular therapy. The aim of the statute is not suppressing speech. Indeed, Chiles's claim that her otherwise protected speech is being swept up by Colorado's otherwise valid treatment prohibition proves that very point. This set of circumstances seems to fit NIFLA's idea of permissible state regulation of professional conduct that incidentally burdens speech to a T. Yet, the majority strangely suggests otherwise with the opinion it hands down today. The majority does this primarily by eschewing serious engagement with the interaction between NIFLA and Casey. Its workaround seems to be, the First Amendment applies full bore here because Chiles's speech is being impacted. After all, she's a talk therapy provider. But when NIFLA's teachings are properly understood, this comeback is no answer. Yes, Chiles happens to be talking when she's providing therapy to patients, but the MCTL regulates the provision of medical treatments by licensed medical professionals, which states are fully empowered to do. That Chiles's kind of medical care involves talk therapy is, in NIFLA's words, merely incidental. I am the first to admit that as applied to talk therapists like Chiles, the MCTL restricts speech. I do not argue that this law really just limits Chiles's professional conduct. Similarly, I do not maintain that because this law primarily regulates talk therapists' professional conduct, it should not be conceived of as a speech restriction. I agree with the majority that, in cases like Cohen versus California, we firmly rejected a state's attempt to suppress free speech by calling the restricted expression conduct. But here, the observation that the MCTL indeed restricts Chiles's speech, not reformulated as conduct, just raises the question that this case presents: whether the MCTL is restricting Chiles's speech incidentally to its regulation of medical professionals' treatment-related conduct, such that the law warrants less scrutiny under the First Amendment than a law that restricts her speech as speech. The majority's failure to acknowledge that this is the actual issue here, not just whether Chiles's speech or conduct is being restricted, but what the state is doing, ignores what has always been true under our precedents. The real lesson of NIFLA's discussion of Casey is this: when a healthcare professional's speech is not being targeted as speech because it conveys an idea, but is instead incidentally restricted due to a state's otherwise legitimate regulation of the medical treatments being offered to patients, heightened scrutiny is not warranted. Subsection 3. NIFLA's focus on a state's regulation of medical treatment also undermines the position the United States has taken on today's First Amendment question. The United States, joining this case as amicus curiae, insists in essence that when the NIFLA court acknowledged that states can regulate professional conduct while incidentally restricting speech, it was blessing only two circumstances. One, where the speech that is being restricted is inextricably tied to an act of the speaker, so speech-only therapists are never included, or two, where speech is being regulated in a manner entirely unrelated to its content. But under NIFLA's reasoning, that cannot be so, at least not logically. With respect to the first category, the United States mistakenly swaps integral, i.e., whether the restricted speech is bound up with the regulated conduct, for incidental. But these are two completely different concepts. Footnote 4. Under the reading the United States advocates, the line between permissible and impermissible state regulation seems to turn on the relationship between the restricted speech and a physical act of the speaker. So, the argument goes, the First Amendment allows state regulation if the speech restriction is incidental to a physical act of the healthcare provider, but prohibits it if there is no physical act for the speech to be incidental to, because the provider treats patients solely with speech. This logic rests upon the integral nature of the speech to the conduct that is being regulated, but that is different from and says nothing about whether the speech is being regulated incidentally, which is the line that NIFLA draws. Carrying on. Given NIFLA's focus on the incidental nature of the challenged speech restriction, the state's objective is the actual fulcrum. We ask whether, on the one hand, the state's law is restricting the provider's speech incidentally, meaning in the course of the state's pursuit of its primary objective of regulating the provision of medical care, or, on the other, the state's law is restricting her speech as speech, primarily to suppress its message or expressive content. The appropriate scrutiny level logically follows. Incidentally restricting speech needs less scrutiny because we view the state as generally regulating the provision of medical care, while restricting speech as speech receives heightened scrutiny because the state is aiming at professional speech qua speech. The second speech incident to conduct category the United States advances, whether the restriction on speech is unrelated to its content, is also fatally flawed. It ignores what NIFLA plainly recognizes, that states can regulate the medical treatments healthcare professionals provide to patients without running afoul of the First Amendment, even if the regulation applies to and restricts speech based on its content. In other words, what mattered to NIFLA's analysis was not that the regulation was content-based, but instead that the speech was being restricted incidentally. So it is here. Talk therapy is a medical treatment. So, why wouldn't such speech based medical treatments be subject to reasonable state regulation like any other kind of medical care? The United States and the majority just insist that a law that undertakes to regulate speech based medical treatments is presumptively unconstitutional because the treatment is being administered solely through speech. But that reasoning is maddeningly circular, and it is based on happenstance, not logic. Even more important, it is not the rationale upon which NIFLA's analysis relies. To the contrary, with its description of Casey, NIFLA recognizes precisely the opposite. A state can regulate professionals' treatment related conduct even if doing so impacts treatment related speech. Again, what distinguished NIFLA from Casey was the fact that Pennsylvania's speech related mandate was aimed at regulating the provision of medical treatments to patients. The fact that the particular medical treatment at issue in Casey involved a physical instead of a verbal act was of no moment. The reading of NIFLA the United States favors, which the majority appears to endorse in part, is irrational because, for purposes of the state's regulation of harmful professional conduct, treatments administered through words versus treatments administered through acts are not meaningfully different. Footnote 5. The majority appears to adopt a theory of the speech incident to conduct doctrine that is analytically similar to, but ultimately narrower than, the recitation adopted by the United States. But just like the United States, the majority fails to account for NIFLA's conceptualization of the doctrine as turning on the state's objectives. Indeed, the majority's analysis offers no cohesive narrative to explain either why this exception to heightened scrutiny exists, or how, like all exceptions, it operates to consistently affect a balance of the public's interests, here free speech and the personal safety that medical standards secure. Carrying on. By contrast, NIFLA's actual line marks a real, constitutionally relevant distinction. Restrictions of speech that occur when a state undertakes to regulate the treatments that professionals provide to patients are merely incidental. They are materially different from speech restrictions that are not tied to a medical procedure at all. The latter warrants strict scrutiny since the state is regulating speech as speech, while in the former case, where the state is merely restricting speech due to its regulation of medical treatments, heightened scrutiny is not needed. The speech incident to conduct doctrine thus ably balances the interests at stake by accommodating a state's traditional police power to regulate the practice of medicine for the protection of its residents while also ensuring that speech is not being targeted. As we explained in NIFLA, that doctrine recognizes that the treatments provided by licensed medical professionals can be prohibited even if, by doing so, the state incidentally restricts those providers' speech. This is constitutionally permissible precisely because the restricted speech is not being regulated as speech, i.e., based on or due to its message or expressive content. Rather, the speech restriction is a mere byproduct of the state's healthcare regulation. So at the end of the day, I think what we have here is what Casey involved and NIFLA did not. A state restricting medical providers' speech only as part of its regulation of the provision of medical treatments to individual patients. And it is precisely because the MCTL is restricting Chiles's speech only as part of her practice of medicine that the First Amendment is not particularly bothered despite the impact on her speech. Accordingly, talk therapists like Chiles, just like any other healthcare provider seeking to treat patients, can presumptively be subjected to reasonable licensing and regulation by the state. Section B. The conclusion that a state can regulate the provision of medical care even if, in so doing, it incidentally restricts the speech of some providers fully comports with the First Amendment's animating principles. These principles include the well-settled notion that context matters when evaluating First Amendment challenges to state regulation. The context that frames today's debate is the kind of speech that is at issue here, what I am calling as shorthand professional medical speech. That is the only type of speech the MCTL restricts. Subsection 1. Properly defined, professional medical speech is a narrow category. It is not all speech uttered by professionals. Rather, it is speech by healthcare professionals made as part of their provision of medical care to patients. To be even more specific, professional medical speech occurs when a medical professional speaks to a client, 1. In the context of the professional-patient relationship, 2. On matters within the provider's professional expertise as defined by the medical community, 3. For the purpose of providing medical care. First, professional medical speech is speech uttered within the bounds of the professional patient relationship. That relationship imposes certain duties and restrictions on the medical professional. For example, medical providers are bound by the twin duties of beneficence, the obligation to act for the benefit of the patient, and non maleficence, the obligation not to harm the patient. Footnote 6. This means, of course, that a provider is not employing professional medical speech when speaking outside of the professional patient relationship. The provider who gives a speech touting the benefits of conversion therapy or writes a paper criticizing those who do not practice conversion therapy or even expresses to a patient her general non-treatment related views about conversion therapy does not have the duties that arise in the context of the professional patient relationship and accordingly is not engaging in professional medical speech. Carrying on. Second, professional medical speech is speech within the healthcare provider's area of expertise as a member of the medical community. Within the professional patient relationship, the professional has knowledge that the patient does not have, including knowledge of which medical treatments are appropriate and how to administer them. The patient comes to the provider to access that expertise, which is informed by and constrained by what the medical community knows. Finally, and most importantly, professional medical speech is made for the purpose of providing the patient with medical care. This speech is a tool employed to treat patients. In this sense, professional medical speech facilitates the professional's goal of providing the patient with the treatment, procedure, or health care that is within her expertise and that forms the basis of the professional patient relationship. Subsection 2. Keeping in mind these characteristics of professional medical speech, consider the First Amendment principles that serve as guideposts for determining the level of scrutiny that a government restriction of speech deserves. First and most fundamentally is preservation of the marketplace of ideas. Indeed, the whole project of the First Amendment stemmed from the founders' desire to protect the critically important goal of having a well-functioning sphere of expression in which citizens have access to information from many sources. Within the marketplace of ideas, speech that is expressive of the speaker's thoughts and views is, generally speaking, highly valued. But professional medical speech does not intersect with the marketplace of ideas. In the context of medical practice, we insist upon competence, not debate. The degree to which medical providers speaking within the boundaries of providing patient care can express themselves is limited because their interactions with patients are constrained by their well-established duties to those patients and the requirement that they meet the standard of care. Moreover, given these limits, professional medical speech does not necessarily involve the expression of ideas or messages, so it does not provide significant value to the general marketplace. That's not to say that there isn't a robust marketplace of ideas within the medical community. Medical professionals contribute to that particular marketplace by writing papers, giving speeches, and pushing the bounds of the community's knowledge through experimentation. And indeed, the standard of care for a medical treatment can be greatly influenced and changed by virtue of such speech. It is there that truth competes for acceptance in the market, but that marketplace exists outside the confines of the professional-patient relationship. Within the confines of the professional-patient relationship, treatment-related truths are a given. They are set by licensing and malpractice standards, and it is not uncommon that such regulation incidentally restricts provider speech. Moreover, regulation of the practice of medicine is pervasively and unavoidably viewpoint-based. The majority and the concurrents both resist this. They relentlessly deride Colorado for engaging in viewpoint discrimination by banning conversion therapy but permitting affirming care. But context makes that point ring hollow. When a state establishes a standard of care or punishes a doctor for providing care outside of that standard, it necessarily limits what medical professionals can say and do on the basis of viewpoint. A state can permissively prohibit the administration of certain drugs for particular medical uses but not for others. Footnote 7. Of course, when the state discriminates on the basis of sex and transgender status with respect to the administration of specific drugs, that discrimination implicates the Equal Protection Clause and requires heightened scrutiny for purposes of the 14th Amendment. See Skirmetti, Justice Sotomayor dissenting. Carrying on. So too may it prohibit a doctor from encouraging a patient to commit suicide, or a dietitian from telling an anorexic patient to eat less. Likewise, no one would bat an eye if a state required its doctors to discourage but not encourage smoking tobacco. Even though these kinds of regulations are inherently viewpoint based in the context of medical care, a state can certainly require the medical professionals it licenses to stand on one side of an issue. Though these prescriptions certainly promote a viewpoint, in this context, that alone does not suffice to establish a presumptive First Amendment violation. Instead, under the speech incident to conduct doctrine, the challenged laws must also operate as speech suppression tools designed to vanquish free expression. But here, Colorado's clear aim is enforcement of a standard of care that is indisputably applicable to the state's licensed healthcare professionals. Taking a position as to how those providers should handle a medical issue is the very essence of standard setting. Once again, this kind of viewpoint based regulation ensures competence, not debate. My colleagues' contrary conclusions are puzzling, for a standards based healthcare scheme cannot function unless its regulators are permitted to choose sides. Footnote 8. Faulting Colorado for legislating based on its view that conversion therapy is harmful for minors and that affirming care is the better treatment, the concurrence purports to save for another day the question whether content based but viewpoint neutral laws regulating speech in doctors' and counselors' offices comport with the First Amendment. But that magnanimity is a mirage. Standards based regulations exist in the medical context precisely because the state has a view about safety or efficacy. Regulation is a state's police power prerogative to promote those views as the standard of care while simultaneously rejecting all others. The laws I reference in Part 4 Infra are not examples of content based, viewpoint neutral laws as the concurrence maintains. Rather, when properly analyzed, those laws are either facially viewpoint based or unavoidably viewpoint based in application. Consider, for example, a therapist disciplined for failing to provide care that promotes the best interests of her client. Punishment for a violation of that standard requires the state to impose its view of what a therapist should have said or done, and would necessarily reflect the state's disapproval of the speech the therapist actually employed. But of course, imposing the state's view of what is appropriate is the entire point of standards based regulation. The First Amendment allows this because the state is regulating professional conduct, and this professional speech is only being incidentally restricted. The analysis does not turn on whether the state's regulation is viewpoint neutral. Neutrality is not and cannot be the touchstone of the laws that govern the quality of care that professionals provide to patients. Carrying on. A second and corollary First Amendment principle is the listener's interest in receiving information. In the professional medical context, however, informational asymmetry shapes the listener's interest. To be sure, respect for patients' autonomy is a cornerstone of medical ethics. But that interest is not served by receiving all existing opinions. Only information about treatments that are within the standard of care advances patients' interests. Patients are not in a position to wade through medical discourse and independently evaluate the best treatment for their circumstances. Their interests as listeners are thus limited by the nature and purpose of the professional-patient relationship. Third and finally, the First Amendment protects a speaker's autonomy. The fundamental rule of protection under the First Amendment is that a speaker has the autonomy to choose the content of his own message. But here again, with respect to professional medical speech, healthcare providers do not have autonomy. When it comes to providing treatments for their patients, they are bound by the standard of care and are not generally free to choose the content of their message. Put differently, although medical professionals do have an autonomy interest in communicating their ideas to the patients they are treating, that interest only extends to treatment-related advice and information that is consistent with the standard of care. In my view, the majority is mistaken to equate treatment-related speech rendered in the context of providing medical care with any spoken words uttered by any other speaker. The majority is also wrong to insist that it is antithetical to the First Amendment for a state to incidentally restrict a healthcare provider's treatment-related speech based on a prevailing standard of care because medical consensus is not static, it evolves and always has. The mutability of medical standards tells us little about the First Amendment's scope in a country where medical standards are enforceable by law and govern the treatment-related conduct of professional healthcare providers. Like it or not, treatment standards exist in America, and those standards necessarily reflect the expert medical community's current beliefs about the safety and efficacy of various medical treatments, whatever those beliefs might be. Medical standards are driven by science, objective facts, and data, but naturally they are not viewpoint neutral. Consequently, the people win, not lose, when a state incorporates the medical profession's viewpoint into laws that require licensed treatment providers to conform to prevailing standards of care. For this reason, the court has long recognized a state's power to regulate to protect its residents even in the face of uncertainty. Footnote 9. The majority laments that because medical consensus is not static, a law like the MCTL might operate to silence professional speech going forward even if medical consensus swings the other way. Illustrating this problem, the majority points to shameful parts of this country's past to show the dangers that can come from regulation that relies on outdated medical practices. But the majority does not mention that, if the standard of care does change, the state legislature has the power to change the law in response to that evidence. The majority's point seems to be that states should not be permitted to enact rigid laws based on current scientific thought because expert opinions might shift over time. But those uncertainties, which have always existed, are no reason to abandon medical standards or to alter how the law has traditionally accommodated scientific discoveries. The potential that medical consensus may change in the future does not mean that the Constitution prevents a state from acting today to protect its residents from what medical experts currently believe is a harmful medical treatment. Carrying on. Put differently, states impose treatment standards incorporating the current consensus of medical experts to protect state residents from harm, and they do this to ensure that professionals provide patients with high quality care. A state that, alternatively, pursues an agenda of purposely silencing critics, muzzling opponents, or targeting views it considers threatening would, of course, violate the First Amendment, but it behooves us all, and especially courts, to see and know the difference. Ultimately, then, no traditional First Amendment principle justifies preventing a state from regulating medical care simply and solely because its law happens to restrict treatment related speech. And in this case, there is zero evidence that Colorado has engaged in the corrosive and illicit suppression of ideas that the First Amendment valiantly repels. The record here does not show that Chiles is being targeted or muzzled or silenced or censored, as the majority suggests. Instead, as a healthcare provider licensed by the state of Colorado, she is simply being held to the same standard of care that all other licensed medical professionals in that state must follow. Footnote 10. Under my analysis, evidence of speech targeting or suppression could include the fact that the challenged state regulation does not, in fact, reflect current medical consensus. If a state enacts a treatment prohibition that substantially diverges from the medical community's present beliefs, the law might well be a pretext for illicit speech targeting objectives. Far from requiring reflexive deference, proof of such motivation would be unearthed and carefully examined as part and parcel of a court's proper speech incident to conduct inquiry, since the doctrine is only applicable to reasonable state regulations. Carrying on. The MCTL's conversion therapy ban only incidentally restricts professional medical speech as a result of Colorado's regulation of a harmful medical treatment. Nothing compels the conclusion that a state regulation that operates to restrict this kind of communication in this way is targeting speech qua speech. Part 3. The centuries-long tradition of states using their police powers to establish and enforce the standards of care that bind medical professionals, including those who use speech to administer treatments, is another indication that heightened scrutiny does not and need not apply here. The majority's opinion largely omits this broader historical record, but when consulted, that history demonstrates unequivocally that the MCTL is neither unusual nor inherently suspect. States have always had broad power to establish standards for licensing practitioners and regulating the practice of professions. With respect to the medical profession in particular, states have used that power to control how medicine is practiced from time immemorial. States have historically regulated the medical profession in two complementary ways: licensing schemes and medical malpractice liability. Both necessarily encompass restrictions on professional medical speech through the regulation of the provision of medical care. Medical licensing began as early as 1639, before this country was founded. Many states deregulated in the mid 1800s by abolishing their licensing schemes, but regulation through licensing was not abandoned for long. By the turn of the 20th century, 12 states had adopted licensing laws. We held that such laws were a permissible exercise of a state's traditional police powers, declaring that the power of the state to provide for the general welfare of its people authorizes it to prescribe all such regulations as, in its judgment, will secure or tend to secure them against the consequences of ignorance and incapacity as well as of deception and fraud. Today, every state has a medical licensing scheme. In practice, medical licensing serves two functions, both essential to patient safety. First, as the majority emphasizes, licensing sets limits on who may practice medicine. But the second function is more important for this case. State licensing laws also regulate how those professionals may practice by requiring them to adhere to a standard of care. While licensing regulates medical professionals ex ante, medical malpractice lawsuits enforce those standards ex post. And just like medical licensing, the tort of medical malpractice has a long pedigree. English common law held doctors liable for harm caused by their negligent medical treatment. The English tradition carried forward. This legal claim has been available in our country since the founding. In the mid-1800s, the number of malpractice cases skyrocketed, filling the void left by the state's temporary deregulation of medical licensing. Historically, the medical malpractice tort generally required the plaintiff to prove three things. 1. That there was a professional-patient relationship. 2. That the medical professional had caused him harm. And 3. That the provider had departed from a standard of care. The majority focuses on the requirement to show harm, but the entire point of the third element was to reinforce the standards that govern medical practitioners. For that reason, the harmed plaintiff was required to establish that the accused physician had not practiced with ordinary care, diligence, and skill. State enforcement of the standard of care, i.e., the care, skill, and knowledge regarded as competent among similar medical providers in the same or similar circumstances, has continued over time and still serves as the touchstone for both licensing schemes and medical malpractice lawsuits. That is, states have consistently regulated medical professionals' conduct to ensure that modern healthcare practices conform to the standard of care through both medical malpractice law and professional licensing. Note, too, that such state regulation has not been limited to medical procedures. Physicians have historically been held liable for what they said when administering those procedures as well. Moreover, in the past, states have, as part of their licensing regulations, defined the practice of medicine to cover practitioner speech. In short, states have regulated professional conduct related to the provision of all kinds of medical care, and incidentally restricted speech, without constitutional affront for eons. Though the majority averts its gaze, even a cursory glance at the broader historical record is illuminating, for it reveals that states have traditionally played a significant role in setting the standards that govern the medical profession. With the MCTL, Colorado has merely taken up that same mantle. The law operates by prohibiting a particular medical treatment the state considers harmful, and nothing about it implicates Chiles's First Amendment rights in a markedly different fashion than other states' traditional efforts to regulate and enforce the standard of care. Footnote 11. The majority's observation that counselor licensure bills are a relatively recent innovation is an interesting diversion, but that is all. The relevant historical question is whether states have historically regulated the medical care that licensed professionals provide to patients, including treatments that are delivered via speech. The answer is yes. The fact that counselors have only recently been included in the regulated category of licensed medical professionals is beside the point. Carrying on. One more thought on this. The majority rigidly imposes a history and tradition test that treats the plethora of historical examples as insufficient, but it should instead find the long tradition of state laws setting standards of care by regulating the professional conduct of medical providers, including those who treat with speech, doubly reassuring. For one thing, this history helps us to be confident that what Colorado is doing here is actually regulating medical care, not suppressing messages. The record shows that states have routinely enacted laws that establish and enforce the standard of care, and that serves as a backdrop for the understanding of how states have acted historically to protect their residents from harm. The majority is right about one thing, however. A state will always say that its law just regulates the provision of medical treatments, while the challenger will inevitably argue that the state's law nefariously targets speech qua speech. A lengthy tradition of similar regulatory efforts by states, or the absence of one, helps courts to ferret out who has the better of that argument. The history also helpfully demonstrates that a lower level of scrutiny is appropriate here, despite the impact of the MCTL on Chiles's speech. We can rest easy, comforted by the fact that this law is not actually operating to suppress the expression of thoughts, messages, or ideas about conversion therapy. Instead, the MCTL restricts talk therapists in the same way and to the same extent as other healthcare professionals have historically been limited when treating patients. Like other valid licensing restrictions, the MCTL does not prevent Chiles from speaking out in favor of conversion therapy, promoting conversion therapy, or otherwise lending credence to efforts to validate that therapy. All this law does is prohibit Chiles from providing this treatment to minor patients, no different than what Colorado and other states have been doing in the indisputably valid exercise of their police powers for centuries. Footnote 12. Suggesting otherwise, the majority places great stock in our decision in Holder versus Humanitarian Law Project. Holder involved a law that prevented lawyers and doctors from providing material support for others' terrorist activities by word or deed. We subjected the law to strict scrutiny because, as applied to the plaintiffs, the law was aimed at preventing professionals from communicating a message. Such a regulation plainly raised the specter of suppression, i.e., that what the United States was really aiming to do was prevent those professionals from expressing support for something the United States found distasteful. In other words, the challenged law sought to punish the plaintiffs based on the expressive content of their speech. That is not what we have here. The MCTL, which follows in a long line of state regulation of healthcare providers' treatment-related conduct, does not restrict or punish medical professionals because of the expressive content of their communications. Rather, the speech restriction happens only incidentally. The MCTL's indisputable objective is prohibiting a harmful medical treatment. To put a finer point on this, the equivalent of Childs' First Amendment claim, transported to the Holder context, would be as if the United States in Holder had said, "You professionals are prohibited from committing acts of terrorism," and the lawyers among them responded, "It is unconstitutional to apply your no terrorist acts prohibition to us because we want to commit the prohibited terrorist acts with our speech." But of course, the First Amendment would not prevent the United States from prohibiting all terrorist acts, even if, by doing so, it incidentally restricts the speech that some actors might otherwise have used to behave in the manner the law prohibits. In my view, that is how Childs' constitutional claim works and also why it fails. Carrying on. All things considered, then, I reach a different conclusion in this case than the majority does because precedent, principles, and history point in the same direction. No heightened scrutiny is warranted here. The First Amendment cares about government efforts to suppress speech as speech based on its expressive content, not laws that, like the MCTL, restrict speech incidentally due to the government's traditional garden variety regulation of such speakers' professional conduct. Part 4. Ultimately, because the majority plays with fire in this case, I fear that the people of this country will get burned. Before now, licensed medical professionals had to adhere to standards when treating patients. They could neither do nor say whatever they want. Largely due to such state regulation, Americans have been privileged to enjoy a long and successful tradition of high-quality medical care. Today, the court turns its back on that tradition, and, to be completely frank, no one knows what will happen now. This decision might make speech-only therapies and other medical treatments involving practitioner speech effectively unregulatable, not to be reached via licensing standards, medical malpractice liability, or any other means of state control. Who knows? Certainly not the majority. It appears to have made this momentous decision without adequately grappling with the potential long-term and disastrous implications of this ruling. The fallout could be catastrophic. Many regulations impact the speech of medical professionals in the context of their provision of healthcare to patients. The possibilities go far beyond talk therapy and informed consent. For example, many states require that medical professionals make every reasonable effort to promote the welfare, autonomy, and best interests of the client. Some states further prohibit medical professionals from treating a patient in a cruel manner. Similarly, some licensing boards can discipline a provider who is incompetent. Footnote 13. Those are not the only restrictions that constrain the speech of medical professionals. Some states require that a counselor make a treatment plan specifying goals and methods and ensure that such a plan is viable and effective. Others prohibit making claims of professional superiority that one cannot substantiate or guaranteeing that satisfaction or a cure will result from the performance of professional services. Still others prohibit the professional from exercising undue influence on the client. Carrying on. On the majority's view, these kinds of regulations become unenforceable if the healthcare provider risks harming patients with their speech rather than an operation. Providers who offer cruel speech-only therapies or who use speech to, intentionally or incompetently, harm the welfare of patients, for example, can now assert a First Amendment right to carry on regardless of these standards. So, to put it bluntly, the court could be ushering in an era of unprofessional and unsafe medical care administered by effectively unsupervised healthcare providers. A state license used to mean something to the patients who entrust their care to licensed professionals, i.e., that the person is certified to be one who provides treatments that are consistent with the standard of care. That stops today. Indeed, it is not at all clear how or to what extent state regulation of medical care involving practitioner speech can survive this holding. We are on a slippery slope now. For the first time, the Supreme Court has interpreted the First Amendment to bless a risk of therapeutic harm to children by limiting the state's ability to regulate medical providers who treat patients with speech. What's next? In the worst-case scenario, our medical system unravels as various licensed healthcare professionals, talk therapists, psychiatrists, and presumably anyone else who claims to utilize speech when administering treatments to patients, start broadly wielding their newfound constitutional right to provide substandard medical care. It is baffling that we could now be standing on the edge of a precipitous drop in the quality of healthcare services in America, but the court sees fit to bring us one step closer to that fate today. Stranger still is the fact that this possibility looms in the 21st century, given what science now enables us to know about medical conditions and treatments, what our cases say, and what we all should have learned by now from history. Somehow, justices from eras past have always understood that, as I stated at the outset, there is no right to practice medicine which is not subordinate to the police power of the states. They correctly applied that simple but powerful understanding of our Constitution across the board to all healthcare professionals, including those with practices that happen to involve treatment-related speech. We do harm to both the nation's medical system and our First Amendment jurisprudence by ignoring that wisdom today. The First Amendment requires heightened scrutiny when states regulate speech as speech, but not when speech is restricted incidentally. The latter occurs where, as here, a state seeks to prohibit healthcare professionals from providing a dangerous medical treatment in all of its forms, including the speech-related variety. States have traditionally regulated the provision of medical care through licensing schemes and malpractice regimes without constitutional incident. And no core principle of our First Amendment jurisprudence leads inexorably to the conclusion that it violates the Constitution for a state to prevent its licensed talk therapists from using speech to harm the minors in their care. Holding otherwise, as the majority does now, flouts centuries of state standardized regulation of medical care and is, ultimately, nonsensical. The Constitution does not pose a barrier to reasonable regulation of harmful medical treatments just because substandard care comes via speech instead of scalpel. Accordingly, I cannot agree with the majority's analysis or its conclusions in this case. The majority finds, at bottom, that Colorado likely cannot legislate to protect the children of its state if, by doing so, it happens to keep state-licensed healthcare providers from saying what they want to say to minors. And the majority's holding means, in effect, that just because Chiles is a talk therapist and not, say, a surgeon, a state can be prevented from incidentally imposing reasonable restrictions on the treatments she provides. Our precedents do not compel this conclusion. In fact, NIFLA draws a different line, and the correct course of action here is to hold it. Speech uttered for the purposes of providing medical treatment may be restricted incidentally when the state reasonably regulates the speaker's provision of medical treatments to patients. To do anything else opens a dangerous can of worms. It threatens to impair states' ability to regulate the provision of medical care in any respect. It extends the Constitution into uncharted territory in an utterly irrational fashion, and it ultimately risks grave harm to Americans' health and well being. That's it for the opinions in this case. And to discuss everything and give our opinions and everything, Will is back. He's returned.
Like a bad cough.
Like a bad cough, but a lot more fun. Yeah,
That remains to be seen.
it's fair enough. Yeah, I don't know. Yeah, I don't know what like your thoughts on the legal merits will be. Like we haven't discussed this before, but I suspect we probably won't differ too much on that. But I figured this was still an interesting enough case that we would still have plenty to say. It's still kind of a big one, so to speak, right? Like it's a First Amendment thing. It has like some political salience with like intersections with LGBT stuff and LGBT minors. So I was like, all right, we'll bring Will on, and it should be fun.
Yeah. This case, I hadn't read it in full when it came out in March, but I did read summaries and passages, just getting the meat and potatoes of it. Um, Revisiting the case, I actually feel a little bit differently about it now than I did when I originally read it. But yeah, I probably in terms of the legal merits, we don't differ very, very much. But they're this was the first case out of the ones that I've done for this show where I was like, oh, Bailey and I might actually have some substantive disagreements here,
Hmm.
because as was fully covered in the opinion itself, this case really hinged on whether Colorado, um, and whether the other lower courts had applied the correct standard for evaluating this First Amendment infringement or impediment. You know, they applied the rational basis review originally in the Tenth Circuit and lower courts, which the standard being is you only need to have the government only needs to prove that there is a quote rational relationship to the
Yeah.
restriction. It is the lowest standard for the government to meet in order to restrict somebody's liberty interests. Versus when you reach a core constitutional power, right? Like, or a core constitutional protection, like the First Amendment, or if it also covers other protected classes like race-based
Hmm.
restrictions, um, then you have to do strict scrutiny. You know, the government has to prove whatever the phrasing is. The
Yeah, it's
government has to
like
prove,
narrowly tailored to serve a
yeah,
compelling
serve a
government interest or
compelling.
something.
Yes, that's
And
exactly right.
in practice, strict scrutiny, like, there's the common phrase, it's like strict in theory, fatal in practice, or something to that effect. Like, strict scrutiny is almost always you can't do that.
Yeah,
Um, and it's also worth noting with rational basis review, if I remember correctly, the rational basis that the government puts forward doesn't even have to be the rational basis that like the law was ratified on. The government can just make
yeah.
something up, and as long
It,
as it
it,
is
it,
a rational basis, the courts will be like, "Yup."
yeah, it's purely anachronistic or
Mhm.
retroactive, however you want to phrase that. Because yeah, it has nothing to do with the actual legislative intent of the thing. It just has to do
Right.
with, as applied, what does the government think is a good reason to keep this provision around? Um, and in this, use that phrase as applied. This was an as applied challenge to
Mhm.
Miss. Is it Chiles?
I think it's Chiles.
Chiles.
I always struggle with these pronunciations, and so I'll, like, have to go back to the oral arguments and be like, "Alright, how did the chief pronounce it?" And I'll just defer to him.
Yeah. Um, you know, this was a pre-enforcement challenge to this law that was restricting, of course, the ability for therapists, in particular talk therapists or speech therapists like her. I think talk therapist is the proper word. Speech therapy is like specifically with helping
Right.
people with pronunciation and shit. Yeah, so talk therapists like her having to avoid or comply with this ban on conversion therapy, right? Whether she was permitted or not permitted, rather, to uh I'm trying to remember exactly how she phrased it because she said, like something to the effect of like, "Oh, my whole thing here is that people come to me and they struggle with sexual desires that they don't have or gender identity issues that they don't want,
Mhm.
and I help them get those results."
Yeah, it's
And
like
that
something to
that
the something to the effect of, like, reducing unwanted sexual attractions or living in harmony with your body, whatever.
exactly. And she's very, like, explicitly, right, like, she's doing it from this Christian perspective,
Mhm.
um, and I don't think it ever really it was never really clarified, at least from my reading, the fact that there was this ministerial exception in the Colorado law. Like, if you were operating from the context of, like, a religious authority, that this law doesn't actually apply,
Oh, I
versus, like
wonder.
her, she was, operating from, well, nominally Christian. She was operating from a professional medical
Right.
context. Um, they never really clarified uh, where the incongruity there, how that would play out in this particular instance. I don't think they necessarily needed to, but that was just a curiosity I had. That I'm pretty sure the original law did create a ministerial exception
Yeah,
for the rule.
I'm guessing. Yeah, 'cause, in the lower courts, as the majority tells it, like, yeah, it was granted that she has, or, it was determined that she has standing, and so, I assume the court was just like, "Alright, well, we'll just assume that and answer this, this question instead." Or, this question that has, like, split the circuits or whatever on what is the appropriate level of scrutiny. So yeah, they didn't have to reach the, like, standing analysis or, like, well, is there actually an exception here? Because I mean, it seemed even like the state was willing to grant, or kind of had to grant, like, "Yeah, we're gonna prosecute her for this."
Yeah,
Um, but, uh but yeah, I don't know, I guess to get my thoughts on the legal merits rolling, I do think the majority gets it right here, and I don't know, I didn't find Jackson's dissent really very compelling. Like, I struggle to see any way around that, at least as applied to talk therapists. This law is just straight up targeting speech as such, and it is engaging in viewpoint discrimination. Like, as applied to talk therapists, it is just straight up, you cannot express anything but acceptance or support or whatever the phrasing in the law was. Now, as applied to other forms of medical treatment or intervention, the law is probably fine because it's not necessarily targeting speech as speech. It just happens that the sorts of interventions that Miss Childs is engaging in is just exclusively speech, and so there's kind of nothing else to target.
yeah. I'm not totally sold on the majority's argument. I think that the proper solution was probably somewhere in between Jackson and the majority. Um, and what I mean by that is I agree with the court's conclusion that strict scrutiny is the proper standard. However, it's pretty heavily implied by Gorsuch's opinion that uh, as is standard for the strict scrutiny analysis, that this bill would not pass strict scrutiny. I'm
Mm,
not actually convinced that that's true. Um, I think that there is. Pretty. I was pretty won over by by Colorado's argument, which Jackson adopted, that um, this kind of activity that Childs is engaging in, though it is exclusively speech, it is speech within the context of providing medical aid or medical assistance, right? Like we can colloquially, we can think of talk therapy as just a couple of people sitting in a room hashing out ideas, but what's happening in the professional context, in the medical context, is that you are providing medical assistance to somebody, and the things you say and how you say them matter more than just a free speech analysis can actually get at. And that isn't to say that this law, as it were, was poorly written. I think it was also poorly written. And Colorado did too. I don't know if you knew, but Colorado amended this law after this decision came out. I
Mm,
think just past May, Colorado, um, yeah, redefined conversion therapy in a
I
way that
was
was more compliant with this decision.
I was gonna
Um,
say, yeah, did they just, like, narrow the definition of conversion therapy? But, yeah, and
yes,
that
yeah,
makes sense because like, that's definitely the easiest way for Colorado to comply with this opinion is just like, "Okay, narrow the definition of conversion therapy, stop," so that it doesn't potentially sweep in so much protected speech.
yeah. There was that it brang to brang. Jesus. I'm an attorney. It brought to mind, the last year's decision, US v. Skirmetti. It was the
Mm,
gender
yeah.
affirming healthcare case, and a lot of that had to do with, hormonal treatments and surgery, um, but it also had to do with just, like, talk therapy, affirmative care, gender affirming uh, conversational healthcare. Like it covered the whole spectrum, and so for purposes of the analysis, I think it's good to include talk therapy in that. That decision, of course, permitted states to prohibit certain forms of gender affirming healthcare because of the effects that it would have on children, um, you know, perceived or otherwise. Um, to me, it felt like it was at least marginally inconsistent of the court to say in Scrimeti, okay, states are allowed to regulate the administration of healthcare for minors on the basis that certain approaches to healthcare are harmful, but then come here and say, well, states can't regulate speech therapy as a medical practice, even if the therapy being engaged with is like accepted in the medical community as a harmful practice
Mm.
because it is just speech, right? I felt like there were two different trains of thought going, and they don't exactly meet in the middle.
Yeah, I mean, I don't know, to me, that seems mostly just a product of, like, you are dealing with 2 different constitutional provisions, right? Like, here we've got a First Amendment challenge, whereas in Scrimeti, it was an equal protection challenge, if I remember correctly.
Right.
It's been a minute since I've looked into that one, although it was cited a number of times in the decision or in the opinions in this case. Um, and so the fact that you've got 2 different constitutional provisions is definitely part of it, and, I guess we haven't had a case of speech therapy that's gender affirming coming to the court, um, but I mean, it would shock me if the court, like, went back on, the child's reasoning if, it happened that the speech therapy was, uh, gender affirming, so, I do think, like, if a state tried to, ban gender affirming talk therapy, in the manner that Colorado did here, like, you would reach the same result, so I guess I should say the court would reach the same result.
Yeah.
Um, so I
I
don't
would hope
think
so.
there's yeah, I certainly hope so. Um
The just I guess, and to sort of like even pull back on my own the thing I just said. Uh it's very clear that this is new legal territory, and
Yeah.
so the court isn't aspiring to necessarily reconcile its decisions across the entire spectrum of the Constitution. It's just trying to say, like, okay, in this context, we can cast a pretty wide net and say these kinds of prohibitions are acceptable. But then in a more narrow context, I think the First Amendment is probably a narrower context for purposes of this as
Mhm.
applied challenge. Um, we can bring the net in a little bit and say like,
Yeah.
okay, well, we said probably more than we needed to say in the last case, and so by narrowing the rule under the First Amendment context, and that's why I described it as a marginal inconsistency, right? Like
Right.
this is not a categorical contradiction. It's just the court is figuring out under which circumstances it's willing to accept its own reasoning. Um, and the more cases that it handles to be able to rein in the wide net it casts in Scrimeti, um, the closer you'll get to what the court actually believes, as a universal rule versus just these broader contexts in which it has to work on a case by case basis.
Right. And yeah, I remember, when Chiles was granted and argued, there was some discourse about it because it kinda had the makings for a big, like, politically salient case, and yeah, that was one of the bits of discourse was, "Oh, I can't wait for the court to say how it's totally fine to ban gender affirming care, but totally, also not fine to ban, conversion therapy," and I'm like, "Okay." And this is something that bugs me a lot about discourse about the court going on a bit of a tangent, is that people
We
look
talked
at
about
things.
court discourse last time too. It's just
This
it's
is true.
such a deep well of weird misconceptions and fallacious expectations. I'm sorry to interrupt. You can continue.
Yeah, um it just that people tend to look at things at much too high a level of generality and with much too little concern for what the legal question actually being answered happens to be. And so you'll get these accusations of inconsistency like, "Oh, well, when it's gender affirming care, it's bad, but when it's not, when it's gender disaffirming care, I guess, or conversion therapy, it's cool." And it's like, well, again, different contexts, different constitutional provisions, different laws. Like, yeah, um, it's not necessarily inconsistent. Not that the court isn't ever inconsistent, it certainly is, but
Yeah, it's important to note, like for posterity that this case this case on paper at least doesn't affect any of the other whatever it is 20, 30 states that also have conversion therapy bans, right?
true.
Like this is a common practice, not a majority practice in the United States, but it's a common practice or provision to restrict the ability of therapists to engage in um, conversion therapy, right? Whatever form that manifestly takes. And this case does not affect the other states. This is just an analysis of Colorado law and Colorado and the lower courts' use of a certain standard for evaluating that standard of review.
Right.
Um, I see this case going back down to the courts and failing rational basis, but it might also be moot considering that Colorado has changed their law. So
Mhm.
it might not even get to that stage. But again, as I've expressed, I think that in a just world, it actually would pass not rational, pass strict scrutiny review.
Yeah,
Ironically, my perception of strict scrutiny is probably not as strict as the courts tend to apply it.
yeah,
This sort of fatal in practice kind of idea that has certainly bore bore out.
yeah, I'm definitely not convinced it would satisfy strict scrutiny. 'Cause, yeah, again, at least as applied to talk therapists, like, it's certainly it's engaging in or, the law is engaging in, like, viewpoint discrimination, at least, again, as applied to talk therapists, and I don't know, I struggle to see a compelling interest that this law is narrowly tailored to serving. I would assume maybe the state would say like, "Oh, well, we're trying to protect minors," but that seems to me like way too vague a sort of interest or broad a sort of interest.
True, and the law
And
doesn't. I think it covers more than just minors as well. It's anybody seeking this kind of like therapy.
Oh, I thought it was minors, but
Maybe
I might be
maybe it is just
mistaken.
minors. I could be mistaken on that. Apologies if I am. But regardless, um I would argue that the restriction is comparable to other medical practices. Like if I could uh, entertain an analogy, right? If I'm going to the doctor, right? I'm going to my primary care physician and I say like, "Hey, there's a part of me that really wants to quit cigarettes, but like I love smoking cigarettes." So like and my family smokes cigarettes, they think I should smoke. Do you have any could you like help me get better at smoking? Or could you help me like, what are some strategies, some brands? Like could you just talk to me about like the best way to smoke basically? Um I would find it incumbent upon that doctor to not offer that kind of advice because it's medically contrapositive. It's medically antithetical to the kind of job that a doctor is supposed to be performing. If you go to that doctor outside of the clinic, outside of the hospital, uh, over, at the bar with a beer and just say, "Hey, Ralph, like, what can you tell me about smoking?" That's one thing. But when you are in the medical context, in the professional context, engaging with somebody as a client, I think that there is a standard of care that rises above your core constitutional protections to First Amendment rights. Um, and as much as the court wants to distinguish between like, you know, medical interventions on the one hand that involve like quote unquote conduct or like whatever that manifestly looks like over and above speech,
Mhm.
I think it is just as important to treat speech itself as a kind of medical practice for purposes of these analyses. Um,
Right. Well,
if and so just to wrap up that thought, if
mhm.
somebody is engaging in pure speech, but they are doing it in the context of their professional capacity as a doctor, licensed therapist, you know, nurse, whatever, um, then that standard of care has to be higher than just the First Amendment analysis.
Yeah, well, and that's where, like, you get the majority talking about, these sort of historical, uh or these concepts with very long historical, pedigrees and the concurrence, Kagan and Sotomayor's concurrence,
Mhm.
talking about, like, the distinction between content-based and viewpoint-based, uh, restrictions because yeah, I think if the state is asserting this interest in, like, setting the standard of care, making sure doctors are acting in the best interest of patients, not harming patients, okay, maybe you've got a compelling interest there, and historically, yeah, states have been able to regulate in order to ensure those things. But then you might fail on narrow tailoring issues because or on narrow tailoring grounds because, as the concurrence kind of points out, you don't have to engage in viewpoint discrimination in order to engage in content discrimination, right? Like you can prohibit lying to patients, for example, speaking to patients in or how do I put it? Engaging in speech with patients that has a false content without engaging in viewpoint discrimination because, well, it doesn't matter what viewpoint you're expressing. The fact is you lied to the patient, and that's what the
Mhm.
state is concerned about. And so, I think you can serve this interest just fine with those sorts of restrictions and medical malpractice, enabling medical malpractice suits and whatnot.
Yeah. That's I and I'm sympathetic to that argument, I think the another thing about the Colorado law that isn't relevant to this particular decision is that the at least the amendment, right, this May amendment that they did that narrowed the definition of conversion therapy. It also made it easier for people who were harmed by talk therapy practices, conversion therapy practices, to bring malpractice lawsuits.
Mm.
Um, which, yeah, insofar as you can demonstrate harm there, I think that that is um, a valid source of recourse for those kinds of actions. I just am not sure that I fully am on board with this First Amendment analysis. I think that it falters, and I guess I'm reaching that point where I'm struggling to articulate exactly where, but I think that it comes short of it comes short of what I would have expected for the court to conclude under these circumstances.
Yeah, I mean, to be clear, the court here wasn't really answering the question of, like, the outcome of the strict scrutiny analysis. I mean, the majority certainly seems to have its view on that, but, the question here is just, does strict scrutiny apply? And I think I think we kind of agree definitely as to that question, yes, strict
Yeah.
scrutiny applies. And yeah, as to that question, I whenever I read a majority opinion, if there's a dissent, they're always arguing points that the dissent brings up. And I always ask myself, like, okay, is the majority mischaracterizing the dissent? And yeah, here I got to the dissent and I'm like, no, I think the majority does a pretty good job of just of accurately representing and dispensing with the dissent's arguments, because I really did not find Jackson compelling at all. Um, a lot of it just struck me as the majority said, just kind of this labeling game, like, well, it's medical treatment, so it's conduct, so it's speech incidental to conduct. And I also think she was doing the speech incidental to conduct analysis wrong, like looking at sort of the overall statutory scheme and like, well, it's aiming at conduct. And it's like, but that's not the question. It's what did it hit? And
Yeah.
here it hit speech and nothing but speech because there's nothing else to hit.
I mean, and that's why I disagree with that's probably the main reason I disagree with Jackson is I think that this is a great example again of like your heart is in the right place, but the law is not on your side. I don't think Jackson she was too optimistic about the fact that the law was as you already said, the law was saying something, the law was hitting something by its own words. It was hitting something that was not what Jackson was arguing for. It
Hmm.
was hitting something that was constitutionally suspect. And that phrasing can be changed. You can write these laws in a way that uh, operates within the confines of First Amendment protections and doesn't fall victim to these sort of gaps, these issues. Um, but what the dissent what dissenters like Jackson often try to do, for good or for bad reason, I think that the circumstances differ. What dissenters often do is they try to reframe the laws as written in a way that would make them constitutional, that would make them legally permissible under the rules as we have already established. It doesn't make them so, right?
Hmm.
And so for Jackson to make her case, and as I've hinted or suggested already, um, I am pretty sympathetic to the idea that like we can distinguish between core constitutional speech and like speech in the medical context. Uh, but the bill doesn't do that. The law didn't do that sufficiently. It did. It was ambiguous enough at the very least that it raised the specter of a First Amendment challenge. Um, and so it was right, I'd say, under the standards and protections of our legal traditions. It was right that Chiles brought this challenge and that the Colorado legislature responded by amending their bill, by amending their law.
Yeah.
You know, it wasn't the court's place to say oh, actually, we should understand it this way so that it is right, so that it
Right.
works. It's the legislature's place to say, "Oh, yeah, we did get it wrong. We should re-articulate ourselves in a way that's compliant with this finding or this decision, this holding."
Yeah, and I mean, there is the practice of, like, I don't know, it kinda reminds me of the practice of constitutional avoidance, like, yeah, the court will adopt when when permissible, when the text of the law kind of allows an interpretation that doesn't raise a constitutional problem or, potentially, like, an inconsistency with another statute or something, the court will try to read those harmoniously, but, yeah, I don't really think the court could hear, and Jackson Jackson's attempts to, like, reframe the analysis just weren't really consistent with what the law actually just plainly does. And then, like, other than the straight up legal merits, one gripe that I had with Jackson's dissent was, like, the, uh the parade of horribles at the end. I always dislike the sort of consequentialist reasoning in legal arguments. I especially hate parade of horribles style, sky is falling sort of consequentialist arguments, and there was just a lot of that here. Like, nobody knows what'll happen, worst case scenario, the court might have just destroyed the medical field and made it completely unregulable. I'm like, "None of
Yeah.
this is true." Like, we know what's gonna
Threatens to
happen.
impair the state's ability to regulate the provision of medical care in any respect.
Mhm.
Bit overdramatic.
Yeah. Yeah,
And it feels like increasingly, and I'm not a court scholar by any means, but it seems like increasingly over the past couple of years, couple decades of decisions, we've seen a lot more of this, where uh, uh, whether it's in the majority or the dissent, right, like or any of the concurrences, where the justices will be so adamant about their position that they will suggest or explicate the idea that the alternative is the end of the legal system as we know it, or it's the end of the medical system as we know it, or it's the end of the business world as we know it, or just like
it's the end of the republic.
it's incredible. I don't like the word extremism. I think it's overused, but
Yeah.
it's there's a sense of desperation and hopelessness that is being communicated by these opinions that I think is just not congruent with reality. Insofar as we continue to have the legal institutions that we have, it is a self-correcting system,
Mhm.
and so I do not accept the 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 fanfare of the justices um, being so concerned with the consequences of their actions that they wager that the opposing side is trying to destroy something. It just doesn't correlate with reality. Albeit, I think some court decisions are so broad spanning that they hurt a lot of people. But again, that kind of consequentialist reasoning isn't necessarily relevant to legal analysis. And again, it's never like this will inevitably or irreparably destroy medical care,
Yeah.
right? Like this is we're talking about one state's one law covering one area of practice. And I think that the court is generally cognizant of its consequences, right? Like it repeats often that it doesn't use consequentialist reasoning in its majority analysis, or it tries not to do that because it isn't relevant. Um, but I think the court is generally cognizant of the fact that its decisions have consequences, and it's not going to accept a decision. It would be ludicrous to read into the law, to read into our Constitution, a conclusion that would bring about our country's destruction. That is a kind of like that is the in terms of rules of statutory interpretation or constitutional interpretation, that is the meta rule that undermines all the other rules. It's like say what you will about textualism or whatever, like no no jurist is going to read the Constitution in a way that the application of its rules would destroy the country. That's not that's
Yeah,
just
and, like,
and sorry, that was a bit of a
it's
tangent. I just Jackson's decision, really smacked of that, and it's just not
yeah,
reasonable.
and well, yeah, and like you said, like, a lot of these things are just self-correcting, yeah, I mean, like, the state has already corrected its law and, amended its law to, still serve its interests, in compliance with the court's decision, so, like, yeah, these are self-correcting sort of entities, so it's kinda really hard to destroy them with one Supreme Court opinion, unless it's just absolutely deranged reading of some, like, foundational constitutional provision or something, but, yeah, just nothing ever happens, the sky never falls, the flood of litigation never comes, I don't know what else, the republic continues on, like,
Yeah.
the parade of horribles reasoning is, like, almost always just safely disregarded, and to be fair, the majority did a little bit of consequentialist reasoning too, in one
Yeah.
section where, like, it was talking about, the sort of, like, standard of care argument and, the dangers of the state, like, codifying a medical consensus in the law and cited Buck v. Bell for that proposition, which I thought was just hilarious, but also a little, I don't know, silly.
Yeah. Yeah, if it slightly goes outside the confines uh, of this show, but, if people are worried about the government, overstepping their authority in a way that undermines, the longevity of the republic, those decisions are not gonna be coming out of the Supreme Court. Those decisions are gonna be coming out of the executive branch or, God forbid, the legislature. But
Yeah, right, like
it's not gonna be the Supreme Court that's doing.
yeah, the political branches are bigger, threats to, whatever your end happens to be with liberty, the continuity of the republic, whatever, like, the political branches, uh, as long as they're, like, actually using the powers that they have, are way more powerful than the judiciary, as intended by design. Yeah, I guess the only other thing that I think I kinda had on this case was just, like, the interesting kind of political dynamics, that you've got well, I guess I'll kinda start this way that, like, as I kind of alluded to earlier, when the case was granted and argued, there was a bunch of discourse, a bunch of controversy, Supreme Court, First Amendment conversion therapy, LGBT minors, like, big politically salient issues, and then when it was decided, I don't know if you saw anything, I didn't see anything. The people talking about it that I was arguing with and talking with and whatnot weren't talking about it anymore, and
No, it became a total, I don't wanna say a non-issue, but yeah, it
right.
really the conversation kinda terminated. Well, and I think it's because the decision wasn't this sky falling, like the court, which I maintain sometimes oversteps the bounds of the question in order to decide
Mhm.
political issues, uh, did not do so in this case, as was so worried. They didn't go out and sing the praises of conversion therapy. They didn't strike down the laws across the United States. Uh, they didn't do the things that advocates were worried they were going to use this case as a vehicle for. And so there
Yeah.
was nothing to talk about. It was
Yeah.
like, "Oh, okay, the law they should have evaluated the law under this different standard, and it probably won't pass that standard." And then 2 months later, Colorado changed the law anyway, so
Right. Yeah, and
no,
I
I did
guess,
not
like,
see a lot of discourse after the case came out. I saw, like, maybe 1 or 2 articles about it, and then just deafening silence.
yeah. Um, I guess slight aside, speaking of, like, overbreadth of the decision, Gorsuch decision, or Gorsuch authored opinion, and I think like one of the first sentences of the opinion was, the question presented is a narrow one. I'm like, yeah, that's
Yeah.
Gorsuch. Editing Bailey here. It was actually the very first sentence of part 2 of Gorsuch's opinion. But yeah, like I think part of it too is that it wasn't like it was 8-1. Like I think that
Yeah.
definitely plays a role that yeah, this was not the the sort of stereotypical 6-3 partisan split.
Mhm.
And it kind of brings up something that I've talked about, that I've heard other people talk about, where it's a common perception the court's very partisan. We've talked about that before, and one of the rebuttals to that is, well, the overwhelming majority of the court's decisions are unanimous, near unanimous, or not, or they're weird splits, partisan wise. Um, and a common rebuttal to that line of argument is, well, those are just the boring cases. Those are the uninteresting cases, the ones that aren't politically charged, whatever. And this is a good example of this is a good example of what I think is the flaw in that argument, that being that sometimes part of what determines whether a case is big, politically salient, interesting, newsworthy, whatever, is whether it's decided on partisan lines. And so when it's not, cases like this that have the makings for you know big and interesting, politically salient decisions just kind of don't uh don't get covered, don't get talked about, because yeah, like you said, there's nothing to talk about. The court didn't overstep its bounds here, and it was a quote unquote bipartisan decision. So
Yeah. You know, I don't want to speak to the broader trends because I'm not familiar enough with the data. My intuition is that there is increasing partisanship on the court, but it's not like the sort of straw man that we can easily tear down is the idea that it is so transparent that like any case can be predictably decided along the 6-3 divide. And this is a clear counterexample of that, right? Like it's whatever the case is statistically about the trend towards 6-3, 5-4 decisions or whatever along partisan lines. We can say with confidence that not every case is going to be decided like that. And it's because, on some level, all of the justices here are operating on an objective legal analysis, right? They're not consciously trying to effectuate partisan goals. I think that there's some nuance at play in that analysis there. I think we can say that, a justice nominated by a political partisan, as justices are more
Mhm.
likely to agree with that side of the aisle than they are to not. Um, but it's not like it's a foregone conclusion in any case. And it would be good, I think, for people to stop treating it like one,
Yeah.
because at least in my mind, if you treat every case like it's already been decided before it gets there, um, you are promoting the trend towards distrust in the judiciary, and that is undermining the capacity of the institutions to do their job.
Yeah. Yeah, I would agree. I think yeah, speaking on like the sort of like actual trends, I do remember seeing some data. It's not very fresh in my mind, so grain of salt and all that. But um, if I remember correctly, there has been in recent years a slight uptick in, and I do mean a slight uptick in the number of cases that are decided on on partisan lines, the sort of stereotypical 6-3 split.
Mhm.
Um, I don't know I don't know how much of that is attributable to, like, political differences per se between the justices, and how much is, like, there has definitely been a shift in, um, judicial ideology, like, how a judge judges and what a judge is supposed to be. There's definitely a bifurcation there on the court, and, uh a still fairly recent resurgence in the popularity of like originalism and textualism and the adoption of those sorts of um, philosophies on the court.
Yeah,
So
these are all coextensive factors,
right.
um, and because I'm trying to be careful here with my phrasing because I don't want to treat it like the court isn't political. I think that it is, but people are drawing the wrong conclusion from that, right? People are thinking that, oh, because the court is political, it can't be trusted, or because the court is political, that um, we can always anticipate the results of these cases, and so it's creating this sort of binary win lose mentality. When I think that even when we understand the individual justices like governing philosophies and like the who put them in their position, what senate what was the makeup of the senate when they were put on the court, who was the
Mhm.
president when they were nominated, all this stuff. um that's like data that indicates or implies a direction, but none of this is set in stone. These are still like rational individuals who are engaging in an analytical legal process. um, when we start to oversimplify and devalue that by reducing people to their ideological, their simplest form, their party affiliation or whatever, their perceived party affiliation, you're probably going to be wrong more often than you're right. It's just not a great heuristic.
Yeah. Uh, yeah, honestly, I think that's most of my thoughts on the case, or at least all of the ones that come to mind.
I think we might get a similar case in the future, not for a while though. I mean, like, I think this case originally was brought in like 2019 or something. Or the
Mm.
bill it became law in 2019. It wasn't long after that that this case became an issue. Regardless, we might see something similar in the future. Uh, it could even be with respect to Colorado's new version of the law, but I don't see I don't see the court going differently on this issue. Clearly, Kagan and Sotomayor were compelled by the majority argument. For the most part, I was compelled. I think that this is another instance where, despite the politically charged nature of the facts underlying the case, this was a proper legal decision. Um, and all we can do now as political actors in the political space, which is not supposed to be the courts, is respond. you know, Rewrite our laws, or just comply with whatever the court has said, and take each step as it comes.
Yeah.
But that's all I've
Uh,
got.
cool, cool. Well, with that, if I'm asking my friends on the other side of the screen, please like, share, comment, all that fun stuff. Follow the podcast wherever you follow podcasts, and if you'd like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members get access to bonus and exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we'll continue on through the 2025 term. Until then.